That is a lordship. That is a lordship.
Yes.
Lordship, I beg to mention item number 11, lordship. Here the state is yet to file counter lordship. Signature is awaited, so if lordship
State
may
what?
please to grant. 11, item 11,
Oh, I think counter noted file.
lordship. So a week's time may be granted, lordship. Signature is awaited, lordship.
Mr. Jimom, you are for?
And for the state respondent,
But the state is respondent.
state respondent, lordship.
Okay, Judge Jimomi. Okay.
Judge
Correct.
Momin.
Your good name?
Abel Ayemi.
Okay. Abel Ayemi, Land Counsel for the petitioner is present. Start. Mr. Jimomi. Land Counsel for the respondent number. Respondent,
And for the state respondent,
only the state is respondent here.
lordship.
Okay. Praise for submits that the affidavit is ready, but await for signature.
Signature,
Okay. And praise for 1 week time.
lordship.
The prayer is allowed. List is matter after a week. Okay.
Lordship. Lordship, I also beg to mention item 30, lordship.
Item
Item 30,
30.
lordship.
Counter noted file.
No, lordship. We are yet to receive instruction, lordship. So if lordship may please grant 2 weeks time.
Okay. You are for the petitioner.
Yes, Your Lordship.
Okay.
Lordship, we also get to file a reply to respondent 1 to 3.
Okay. Miss
Wickets or no?
Vikit Sono, Land Counsel for the petitioner is present. And prays for some time to file
Reply to respondent 1 to 3.
affidavit in reply to the respondent number, to the affidavit filed by the respondent number 1, 2, and 3. Stop. Mr. Zimomi, Land Counsel for the state respondent, also prays for some time to
File affidavit.
file affidavit. Is prayed for by the Land Counsel for the parties. List this matter after three weeks.
3
Okay.
weeks.
Lordship, I also beg to mention item 33, lordship. Lord-
Three.
33,
Service awaited.
lordship. Lordship, I'll be appearing on behalf of respondent number 2, lordship.
Okay. State respondent.
Lordship, my friend is for respondent number 2, that is Commissioner and Secretary, Department of Works and Housing.
Okay.
I am for respondent number 3, that is Engineer in Chief, MP Community.
Okay. So,
So we have I have instructions for to appear for respondent number 3 and my friend for respondent number 2.
appearing for the first time, praying for some time to file affidavit. Wakalatnama. Mr. Santianger, Land Council for the petitioner is present. Stop. Mr. Jimomi appears on behalf of respondent number 2 and Mr. Moimche, the National Government appear on behalf of the respondent number 3 and prays for some time to file Wakalatnama. Wakalatnama, okay. So the prayer is allowed. List is made after 3 weeks. Okay.
Obliged, Lordship. Yes, Lordship. Lordship, I beg to mention item number 53 and 54, Lordship. Lordship, I am for the petitioner.
Okay.
That if this matter can come up in 2 weeks, Lordship.
Okay. As prayed for by Mr. N. Moju, Land Council for the petitioner. List is made after 2 weeks.
Obliged, Lordship.
Okay.
Yeah, mention item 56 of the hearing list.
After item
56,
Right.
last item.
yes.
This matter can be taken up after 3 weeks. And for the petitioner.
On the prayer of Mr. Eli Ralu, Land Council for the petitioner, list is made after 3
3 weeks.
3 weeks. Okay.
Deeply obliged.
So, okay, you are also, Poseco Pote is for respondent.
Private response. Private response.
Private, okay.
Contact.
Mr. Angami, Land Council for the state, and Mr. Poseco for the Land Council for the private respondents are also present. Okay.
May I please, my lord. Lordship, I beg to mention item number 3, Lordship. Item number, no,
Counter
sorry,
noted file.
item number 7, Lordship.
7.
Yes, Lordship.
7 also noted file.
Lordship here, item 7, the state is preferring an appeal against the order, Lordship. 7, item 7. So, can you grant 3 weeks time, Lordship?
Mr. Poseco for the Land Council for the petitioner is present. Mr. Angami, appearing on behalf of the state respondent, the respondent, prays for further 3 weeks times.
Lordship.
The prayer is allowed. List is matter after 3 weeks.
Lordship. Lordship, then item number 50, Lordship. 50.
Yes.
50. Lordship. Can you grant 50, Lordship?
Yes.
Lordship, it may be listed after 3 weeks, Lordship.
What?
Lordship.
Okay. Mr. Muaz Jamil, Land Council for the petitioner is present. Mr. Angami, Land Council for the state respondent prays for listing this matter after 3 weeks. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Lordship, I have a similar prayer for item number 49, Lordship.
49. So have you informed the Land Council for the
I
petitioner?
cannot locate the promise.
So,
49.
Mr. Angami, Land Council for the state respondent prays for listing this matter after
3 weeks, Lordship.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Lordship, also item number 31, Lordship. 31. 31. Lordship, here I have instruction to appear on behalf of respondent number 2, 3, and 4, Lordship.
2,
3, and 4.
I think the report also awaited in respect.
Yes, your lordship.
Yes,
It's completed.
You'll be complete, Lordship.
Okay.
Yes.
Miss
N solo.
Hmm?
N solo.
and Solo, Land Council for the petitioner is present.
Lordship,
Mr. Angame, put appears on behalf of the respondent number 2, 3, and 4, and prays for some
4
time.
weeks time, Lordship.
Prays for 4-week time to file affidavit.
Lordship,
To obtain instructions.
Yes, Lordship.
Obtain instruction. The prayer is allowed. List is matter after 4 weeks.
Bless you, Lordship.
Okay.
May I please, your lordship. Your lordship, I beg to mention item number 14. Your lordship, we are yet to receive an instruction of filing our affidavit. So I pray that ladies may come after 3 weeks, your lordship.
Your for respondent number
Respondent 1, 2, 5, 6, and 8, your lordship.
5, 6.
Yes, your lordship.
Miss
LBG, your lordship.
Learned Counsel for the petitioner is present. Mr.
Sipong, Your Honor.
Learned Counsel appearing on behalf of
Senior Yanawari, Your Lordship.
Yangarvati.
Yes, Your Lord. CGC
Learned Counsel for the respondent number 1, 2, 5, and 6.
In 8.
6 and 8, Your Lordship.
5, 6, and 8.
Yes, Your Lord.
Praise for
3 weeks, Your Lordship.
3 weeks time to file affidavit.
Yes, Your Lord. To
The
file
prayer is allowed. List this matter after
3 weeks.
3 weeks. Okay.
Yes, Your Lord.
Yes.
Your lordship.
May it please, my lord.
Yes.
In item 30, I believe my learned friend, Yang Kami has already made the mention, lordship. I
Yes.
have no objections to his prayer, but kindly my name may be reflected. I'm appearing for respondents 1,
Okay.
2, and 3.
In the item 30, which was mentioned earlier,
WBC
Mr.
229 of
Mr.
2023.
Sentian Garlani Counsel for the here for respondent
1, 2, and 3.
1, 2, and 3 is also present. Okay.
Much obliged.
May I please, your lordship? I beg to mention item number 42 and 43, your lordship. Lordship, here the petitioner in item number 42 has expired and I have.
Yes, yes.
Yes, and I've been informed that his wife wishes to continue this case. So if kindly grant 3 weeks time to get further
Okay,
instructions.
the right still survive.
Yes,
Okay. Miss
wickets or no,
Learned Counsel for
petitioner
the petitioner,
in item 42.
item 42, petitioner submits that in the instant case, the petitioner expires and his wife
Yes, your lordship. She wishes to continue this
with the
case.
legal heirs of the deceased wants to continue with the petition and file and prays for some time to file substitute petition. Huh? Okay. The prayer is allowed. List this matter after
3 weeks.
3 weeks. Mr.
W. Matter lordship.
Learned Counsel for the
I
respondent
am the respondent in item number 42, respondent number 4, and the petitioner in
correspondent number 4
Item
is
number
also
43.
present. Okay. In 43 also you have mentioned.
43,
It's same.
your lordship, in 43, I'm for respondent 2 and 3.
Respondent
2 and 3.
2 and 3. So who is for the petitioner here?
The,
43 petitioner is present.
Yes, lordship in 43, I am the petitioner.
Okay. So it is with the with 42 can be listed along with the 42.
Yes, your
Yes,
lordship.
lordship.
Yes, lordship.
Okay. In 42, Mr. Learned Counsel for the petitioner is present and Miss
Wickets or no,
Learned Counsel appear on behalf of the respondent number 2 and 3. As prayed, list this matter along with the is they already there only after
Yes, lord.
after 3 weeks, your
after
lordship.
2 weeks. Okay.
3 weeks, your lordship.
3.
3 weeks.
So then the 42 also 3 weeks. Huh? Okay, 3 weeks. Okay.
Obliged, your lordship.
May it please, lordship.
Yes.
My lord, I beg to mention item number 46. Let this matter be listed after 4 weeks, lordship. I'm for the appellant
Okay.
in item number 46.
Okay, Mr.
W. Murphy, lordship.
Your name is not there?
Yes, lordship.
Is
On
there?
behalf of my senior Ajo.
Okay, appearing on behalf of Mr. Ajo, Learned Counsel for the petitioner, prays for listing this matter after
After 4 weeks, lordship.
4 weeks. The prayer is allowed. List this matter after 4 weeks. Okay.
Lordship, I also beg to mention item number 16 and 17, lordship. Lordship, here I have the
16 is a
instruction,
fixed matter.
lordship. I have the instruction to appear on behalf of respondent number 1, 3, 4, 5, 6, and 7, lordship. Here.
You are for respondent.
Yes, lordship.
1, 2,
1, 3, 4, 5, 6, 7, lordship. I have the instruction to appear on behalf of this respondent's lordship.
okay,
So I'll be filing my Bagalat number in the course of the day, lordship.
okay. Miss
Lordship, I am for respondent number 2.
2, okay. Miss
Lordship, I'm for the petitioner.
Learned Counsel for the petitioner is present. Applicant is present. Stuff. So you are in the for this respondent in IA.
Lordship. Yes, Lord.
Okay. Mr.
W. Murphy, lordship.
Your name is there.
No, lordship, in the course of the day, I'll be filing my Bagalat.
Okay, so put appears on behalf of respondent number 1, 3,
3,
4,
4,
6,
5,
and
6, 7.
no, 5 also.
Yes, lordship.
5, 6,
7.
and 7, and
Yes.
prays for some time. Prays for 1 week time to file an
Lordship,
wakalatnama.
Lordship, Bagaladuma, in the course of the day, I'll be filing. However,
Okay.
Lordship, to file affidavit, kindly allow me 4 weeks time. Lordship.
Okay, praise for 4 weeks' time to file affidavit. And then also just wait, and Mr.
Respondent number 2.
Okay, appears on behalf of the respondent number 2, both the Land Council for the respondents, praise for 4 weeks' time to file affidavit, file wakalatnama and affidavit. The prayer is allowed, least this matter after 4 weeks. Okay.
Much obliged.
Your Lordship, I'd like to mention item 41 on behalf of Tivapom. We pray for one, kindly list the matter after 1 week as he's on leave.
Mr. Posego for Tilana Council for the petitioner is present. Mr. His name,
Item 41.
41.
It is fixed for submission of written recommend only.
Okay.
Hearing has already been concluded, Lordship, but your Lordship has directed to file written recommend. Hearing is completed already. Item 41.
Okay. So what do we do then?
We can
He
submit
is
the
seeking
written
for some
recommend.
time. The respondent is seeking for some time.
Hearing
is
is
the- what
already
is the main?
concluded.
Hmm?
So we can submit a written recommend today. For that purpose only this matter
Okay.
has been listed
So
today.
is it ready? No.
Lordship, advocate is on leave. Your Lordship.
Lordship, the last petition,
Hmm.
the council for the government council has submitted that he will be relying on the sub affidavit.
Okay.
So he has filed that with it. Except for the private respondent. the
Okay.
petitioner.
Are you submitting?
Then we can submit.
You'll submit. You're for respondent
For the petition.
or you're for the petitioner? Okay. Petitioner is ready with, okay, you are also ready with. Then what do we do? And only what is Amir for respondent number?
I'm for the state respondents.
Oh,
The
State
council-
respondent is represented by
Okay,
Tivapom
Tivapom.
and
He's on-
he's absent today, Lordship.
okay. So then we'll wait for some time then,
Lordship
if
is.
there is some
Yes.
clarification, if any. We'll wait for some time. Okay. Hmm. Yes,
May I please, Your Lordship,
yeah.
maybe please to mention item number 6, Your Lordship. If it can come up next week, Your Lordship.
This legal, I think this letter is ready for hearing.
Yes, yes, for hearing. The
I think
readings
it's
are
ready for,
completed.
ready for hearing. Can we fix for hearing?
Yes, Your Lordship.
For admission hearing, Lordship,
Okay,
next.
Mr. Muazzamir, Land Council for the petitioner. And then hard Mr. Muazzamir, Land Council for the petitioner, and Ms. Levika, Land Council appearing on behalf of the state respondent. So it is submitted, the matter is ready for hearing. According, ready for hearing stuff, the writ petition is admitted and listed for hearing after
Next week, Lordship.
Next week.
next week. What is this matter about otherwise?
Termination, Lordship. I was terminated from service, Lordship.
Termination.
Hmm.
After a week.
Obliged, Lordship.
May I please, my lord?
Yes.
Lordship, I beg to mention item number 4.
Oh,
4, my lord. I am appealing for respondent number 1.
okay.
Lordship is well aware that this contempt petition relates to minimum scale of pay.
Hmm.
And the government have considered a committee to look into it, Your Lordship. However, the committee could not be set because of the MMC, Your Lordship, the Model Code of Conduct.
Okay. Mr.
Benison Visual.
Likase, something,
Benison Visual.
Okay, Land Council for the petitioner is present. Mr. N. Nangame, Land Council for the respondent submits that due to the imposition of the model code of
MMC,
conduct
yes.
for MMC election, the committee could not set, accordingly pray for some more time. Prayer allowed, list this matter after. So when this will end?
Lordship, it will end on 26th of the June.
After 26th of
June.
Okay. Let's pray, List this matter after 26th of June. Okay. Yes.
Lordship, I also beg to mention item number 32.
Lordship, in this matter, I have instruction to appear for respondent number 4. Earlier, I was instructed to appear for respondent number 1 and 3. However, Your Lordship, I have also been instructed to appear for respondent number 4, and I'm appearing for the first time, my lord, as far as the respondent number 4 is concerned.
And probably there was a partial compliance, and then the recovery process, I think, probably has suspended.
Yes.
Yes.
The recovery has been,
Suspended,
Suspended.
not fully complied.
Yes.
Lordship, as far as respondent number 5 is concerned, Lordship, the Office of the Accountant General,
Hmm.
we have no role to play because there is the issue between the
Of course.
petitioner. Yes.
Hmm.
But anyway, I'll be filing
Anyway.
affidavit. I'll send for getting Lordship.
May I please, Lordship? Lordship, regarding the respondent number 2, I am informed that he has been transferred. So kindly allow me to implement the newly incumbent officer, Lordship, the commissioner, Lordship.
Respondent number
2,
2, you are for petitioner.
Lordship.
Okay. The respondent number 2, what happened to respondent number 2?
Lordship, I'm informed he has been transferred and we,
Transferred.
Lordship,
Okay.
we served the copy, however, they refused to accept. So kindly allow us to implement the newly incumbent officer, Lordship.
Okay. Miss Libby, sorry, Mika, Learned Counsel for the petitioner submits that the respondent number 2 has been, respondent number 2 in the instant case has been already been transferred to some other place, and in his place, some other officer has been posted and praised for some time to implement the new incumbent as respondent staff. Mr. Okay, Nangame,
Lordship.
Direct
Appearing for
counsel for the
respondent number 1, 3,
respondent
and
number
4.
1, 3, and 4 also has instruction to appear on behalf of respondent number 5.
No, number 4.
No, number 4,
Four, no.
sorry. 1 and 3, huh?
Yes.
Also has instruction to appear on behalf of respondent number 4 and pray for some time to file affidavit stuff. Mr.
And Mosre.
Learned Counsel for the respondent number 5 is also present stuff. Is prayed for by the Learned Counsel for the parties. List this matter after 3 weeks.
2 weeks, Lordship.
After 3 weeks.
After 3 weeks.
After 3 weeks.
Okay.
Much.
Lordship, I also beg to mention item number 33.
Item
33, my lord. Mention.
already mentioned.
Okay. Obligement.
May it please, my lord.
Yes.
Lordship, I may be allowed to make a mention for an unlisted motion which is in connection to Lordship, hearing item 37, 38, and 40, Lordship. Here, I am the chief ang of my village, Lordship. I have not been implemented. I am the person who have donated the land, Lordship.
Who have?
Who has donated the land to the government, Lordship. So I have filed an application this morning, praying for including me. I am a necessary party, Lordship. And I believe that, Lordship, if not the proper party, without me, the case cannot, there would be travesty
No,
of
it is
justice.
between the state,
Yes,
the petitioner and the state.
yes.
Yes, Lordship. But I am the person who donated the land to the state government, Lordship.
You were nowhere earlier also.
No, they did not implicate me.
No, how they could implement it? Because it is between the government and the petitioner.
No, I have given the land to the government for a specific purpose.
No,
Lordship.
after receiving from you, the government has allotted him.
No, Lordship, that is why. I have donated the land to the government for a specific purpose,
No,
Lordship.
what claim you have now then, after donating the land to the government?
If, Lordship,
It is with the government. And then government thereafter only have given to this.
yes, Lordship, but that is why,
Private school.
Lordship, in the understanding that it will be used for public development purpose in my area, Lordship, I have donated the land, not for giving it out to some private owners for human cultivation and agricultural purposes, Lordship. And which is why I believe that, Lordship, my interest shall be directly affected, Lordship.
It was already heard.
Yes.
The
Yes,
case was already
Lordship,
heard.
yes, Lordship. Now, without me, Lordship,
Hmm.
if an adverse order is passed, Lordship, then my rights shall be affected, Lordship, and my interest, Lordship, because 1,200 acres is a huge plot of land, Lordship, and I have donated that plot of land, Lordship,
Or
on the,
individual person or representing the village.
No, I am representing the village. I am the chief ang of my village, Lordship.
Ang.
And yes, that is hereditary chief, Lordship, of the village. In
Do you have any
Koyak,
document to show that you have donated the land to the government at that point of time?
Lordship, if I'm implemented, Lordship,
Huh.
if I'm implemented, I will also be, I believe, given an opportunity to file appropriate affidavits before this honorable court, Lordship. And during that time, Lordship, I will, at this stage, Lordship, I am only aware that a case has been filed before this honorable court. I am not in receipt of any of the writ petitions or pleadings exchanged between the parties, Lordship. I am in the dark, Lordship.
No, no, you have participated there. Thereafter also there was a lot of, I think, some direction. And then you have, the village also participated, deciding raising objection, etc. All those you are in, this was in your knowledge only at that time also.
Yes.
It's been, of course, which year? 2017 since.
Yes.
Yes, Lordship, but I am not a party, Lordship. If Lordship, I kindly,
Your Lordship, it is not a disputed fact that the village donated the land. Even the government has made specific
You-
statement. I have also made.
You have already
specific
filed.
statement.
yes, I have already filed this morning.
Okay.
So let it come up together with the
Yes.
hearing matter.
We'll
so
come
that
up together
it-
then,
yes.
okay?
My lord,
Yes.
When?
Today, it's
Today.
listed, the hearing is little so.
Let us see. Okay.
Let his
Lordship.
application also come.
Is it ready? Otherwise,
yes, I have already
Maybe
filed this
tomorrow.
morning,
Ah.
Lordship, yes.
okay.
Yes, they have, the filing section, they have
Okay,
already
wait for
accepted.
some time then.
Much obliged.
Maybe Lordship.
Yes.
Lordship, I beg to mention item number 13, Lordship.
Hmm?
13, 1-3, harmful respondents. Respondent 1 and 2, Lordship. Lordship, I'm yet to
This is
file.
not yet filed.
Not yet, Lordship. Moreover, Lordship, my seniors are not keeping well, so the matter can come up. Lordship.
At least LCR is received.
And share.
So may I brief that many will fix for admission hearing within a short time, Lordship.
Okay, so
Lordship, on the last three occasions, they are asking dime to file contract affidavit as well as the objection, but they are not filing, Lordship.
you file this time?
Lordship,
And their objection is not necessary because records are there, Lordship.
Hmm.
LCR are there.
Okay.
Therefore,
What is Amir? Land counsel for the petitioner, stop. Mr. Fosego for the land counsel for the respond. You are respondent for
1 and 2, Lordship.
respondent number 1 and 2. Pray for further time to file objection. Further, how much time?
2 weeks, Lordship.
2 weeks time. to
I think
file
we will
objection.
fix for admission hearing, Lordship, because LCR is there.
LCA, has it come on record? No. LCA?
Yes, we receive, Lordship.
It has come on record. Okay. Okay, list it after, as prayed for by the land, as prayed, comma, list this matter after 2 weeks.
30.
Okay.
On
And
30th, on
30.
30th of May,
Of May for admission hearing, Lordship.
we'll make an entry
Okay.
there.
As prayed for by the land council for the party, list this matter on 30th. Okay.
3-0, 3-0.
Yes.
Oblige, my lord. Lordship, I also beg to mention item number 5, Lordship.
Item 5.
5. Yeah, for petitioner, Lordship.
Not filed. Reply not filed.
Lordship,
You need to file reply.
yes, Lordship. And Lordship, since my senior is not keeping well, it's a matter come up to 2 weeks, Lordship.
Item 5.
Item 5. 5.
Mr. Pasego for the land council for petitioner. Praise for father, how much time? 2 weeks, 2 weeks time to file affidavit and reply. Sorry. Okay, reply. Okay. The prayer is allowed. You are also appearing? Okay. Mr. Angavilana Council for the state respondent is present. Staff is prayed. List is matter after 2 weeks.
2 weeks. Lordship doesn't interim. Can you let the interim continue, Lordship?
The interim order passed earlier shall continue till the next date. Okay.
Lordship. Lordship, I also beg to mention item number 1 and 2, 2 and 3, Lordship.
2 and 3 also counter not filed.
Lordship, I'm fully responding, so kindly grant me 4 weeks time, Lordship. I'm fully responding, Mr. Lordship.
Who is for the, have you informed the petitioner?
Lordship, the petitioner is here.
For the petition.
Okay, Miss.
Filing an objection, so I need at least 4 weeks time, Lordship.
Land council for the petitioner is present. Mr. Pasego for the land council for the respondent prays for, how much time you said?
4 weeks, Lordship.
4 weeks time to file counter affidavit. The prayer not objected, stop. Accordingly, the prayer is allowed. List this matter after 4 weeks.
Lordship. Highly obliged, Lord.
Yes,
Please, your lordship, I beg to mention item number one.
item
One.
One.
Approving on
Very
behalf of
fine.
Anand
Hmm?
One.
Okay, you are for? Respondent,
Petitioner,
petitioner,
approving on behalf of Anand
on behalf of
Kumar.
N. Long Kumar. N. Long Kumar is for the respondent only,
Petitioner,
petitioner. No, it is against the Oh, this is all Long Kumar. You are for?
I'm representing respondent number 4, Lordship.
Respondent number 4, Miss. Appearing, your
on behalf of Anand Kumar.
Petition.
Rebecca,
Rebecca, appearing on behalf of N. Long Kumar, Land Council for the petitioner. Praise
kindly
for,
list this matter after 2 weeks.
praise for further 2 weeks time to file affidavit in reply. Mr. Okay, Land Council, your good name?
Abel AMA, Lordship.
Hmm?
Respondent number 4.
Respondent number 4.
Yes, Lordship.
Respondent number 4 is all Long Kumar. You are?
No, actually, I'm from respondent number 4. She is the petitioner, but the site has been changed. That's why I'm confused.
Okay. Is present, huh? Is present. List this matter after 2 weeks. You said 2 weeks.
Yes,
Okay.
your lordship. Obliged.
May it please your Lordship.
Yes.
Lordship, I'd like to mention item number 48. On behalf of the Council for the Respondent, B.N. Sharma. Kindly list the matter after 2 weeks, Lordship. Item number 48.
Your Lordship, I'm for the petitioner.
Okay. No objection. Okay, Mr. You are for the petition, Mr.
Jin Young Pom on behalf of my senior Yanawari.
Singyam Phong,
Yes, Your Lordship.
appearing on behalf of Yangavati, Land Council for the appellant. Is present. Stop. Mr.
No more on behalf of B.N. Sharma.
Appearing on behalf of Mr. B.N.
Okay, for the
Sharma,
respondent.
Land Council for the respondent
Yes, Lordship.
number.
We're the sole
So-
respondent.
Okay, so respondent. Praise for
2 weeks time, Lordship.
3 weeks time. Stop. The prayer not objected. Stop. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Obliged, Lordship.
Obliged, Your Lordship. Your Lordship, I beg to mention hearing item number 51, Your Lordship.
Item
51, Your Lordship.
51.
Yes, Your Lordship. I'm for the petitioner. Your Lordship, as my senior is having some personal difficulties, so let this matter come after 2 weeks, Your Lordship.
After
2 weeks, Your Lordship.
okay, Mr.
Jin Young Pom.
Lana Council appearing on behalf of Mr. Yangavati. Sorry, Lana Council for Lana Council submit that his senior Mr. Yangavati has some personal problems and prays for listing this matter after 2 weeks. The
Yes, sir.
prayer is allowed. List this matter after 3 weeks.
Obliged, Your Lordship.
Okay.
Bless Your Lordship. Your Lordship, similar bear will be reflected on item number 44 and 45.
44.
44 and 45, Your Lordship. Consent has been taken from the other bodies.
44 is for record something. 44, you are for, in the 44, you are for respondent.
Yes, Your Lordship. Respondent number 1, Your Lordship.
Okay, and then Miss, okay, Miss, your Miss,
Lordship, I'm appearing on behalf of my senior,
okay.
IMT Lordship.
Appearing on behalf of
IMT Lordship.
Longs. Appearing on behalf of,
IMT Longchar Lordship.
okay, IMT, sorry, Longs. Appear on behalf of IMT Longs. Stop. Mr.
Your Lordship, for respondent number 8, on behalf of Sir Pendang.
And you are for?
Yanawari, Your Lordship.
Okay.
Respondent number 1.
Okay, Mr.
Jin Young Pom, Your Lordship.
Appearing on, no. Appear, submits his name, submits that his senior has some personal difficulties today and prays for listing this matter after
Your Lordship, 2 weeks.
2 weeks. Stop. And you are missed for respondent number 8.
Yes, Your Lordship.
Okay. For respondent number 8 is also present. As prayed for by the Lana Council for the respondents, list this matter after 2 weeks. Okay.
Obliged, Your Lordship.
Lordship, I beg to mention item number 10.
10.
Yes, Lordship, kindly grant us 3 weeks to file a reply.
This
And
is,
for the
I think, ready for hearing. We can list it
10,
for hearing.
Lordship.
Hmm?
Item number 10, Lordship.
10, it's ready for hearing, it appears.
Lordship, we have not filed our reply, so
Oh, you want to file reply
yes,
also?
Lordship.
Okay,
In the previous occasion also, we asked for 3 weeks to file, but
okay.
we were not able to file.
In the order reflected that you want to file a
Yes,
reply?
Lordship.
Okay. Miss,
Miss Obang Nenla Longcha, Lordship.
your name is also there?
Yes, Lordship.
Okay, Obang Nenla Longchair, Lana Council for the petitioner.
Your
Press
Lordship,
for
I'm
some
for the
more time to
respondent.
file affidavit in reply.
Your Lordship, I'm for the respondent.
Okay.
Younger what do you?
Okay, Mr. So-and-so appear on behalf of Mr. Yangavati, Lana Council for the respondent. Is it, respondent, huh? Is prayed for by the Lana Council for the petitioner. List this matter after
3 weeks.
3 weeks. Okay.
Obliged.
Obliged, Your Lordship. Please, Your Lordship.
Yes,
Lordship, I beg to mention item number 15.
yes.
Lordship, I'm yet to receive the petition. I'm yet to go through the petition. So therefore, Lordship, I may be given 4 weeks time to file the necessary affidavit after going through the petition.
You said you have not received.
The petition that they have received, I've been informed that the service of notice has been completed,
Okay.
but I'm yet to go through the petition. 15, item number 15.
Miss
Gates agree, Lordship.
Lana Council for the petitioner is present. Mr.
Chiang Mai,
Lana Council appearing on behalf of the respondent.
number 2.
Number 2,
Yes, Lordship.
what is your prayer, sir?
Lordship, my prayer is that I'm yet to go through the petition.
Okay.
Therefore, I may
Samir
be,
said he has received the petition. He has just received the petition and prays for some time to go through the same. Okay. Yes, prayed. List this matter. Oh, okay. Mr. Jimomi Nan PP is also present. As prayed for by the Rana Council for the private respondent. List this matter after
4 weeks.
4 weeks. Okay.
Lordship, there's an interim.
Okay, stop. The interim order passed earlier said continue till the next stage. Okay.
Lordship, I may be allowed to file the necessary affidavit on going through the petition.
Okay. Praise for some time to go through and to file affidavit if necessary. Huh? Okay. Yes.
For admission, item numbers 8 and 9.
Lordship, on the last occasion, LCR was called.
LCR also. Oh.
By order dated 3/5/2024, whether the LCR has arrived.
LCR received
Lordship.
and scan copy also. You didn't inform that the scan copy was already called for, but we also called for the LCR, thinking that the LCR was not yet called for. Anyway, so what is the case?
Lordship, this is a case where a vexatious FIR has been filed, Lordship.
Okay.
The petitioners and the accused, Lordship, they are ordinary businessmen engaged in the business of agricultural products, poultry products, Lordship, and areca nuts, that is, which we call popularly in Nagaland as tamul.
Yes, this last time we've seen. I think the case has been filed into final report.
Yes. Lordship, then in that case, Lordship, if my learned friend agrees,
Anything to submit? We can send it.
From the
Send it.
LCR, Your Lordship.
Hmm?
We can, Your Lordship can decide on, basing on the LCR.
Okay. Okay. Add Mr. Okay, Yanavati, land counsel for the Sentianger, huh? Land
Yes,
counsel for
Lordship.
the petitioner. This is item 8,
Yes, 8 and 9, Lordship.
8 and 9. I've also heard Miss Mary, land PP. Stop, huh? Para. This is an application under section 482 of the Criminal Procedure Code 1973, praying for passing of FIR and all consequential criminal proceeding pending against the petitioner accused being GR number 602 stroke 2022 in connection with state crime PS case number 07 2022 under section 120B 379 and 411 IPC pending before the Planet Court of Chief Judicial Magistrate, Dimapur, Nagaland. Staff. Where have you annexed the FIR also?
Yes, Lordship, I have annexed.
Where it is? Page? Okay.
Page, Lordship, annexure 2, Lordship.
The case of the petitioner is that a suo motu FIR was lodged by one Ubi I Mekando Audio in charge CID branch, Dimapur. Inter alia stating therein that he has received an information from a reliable source regarding involvement of few antisocial elements dealing in illegal smuggling of contraband and arecanut within bracket supari bracket close from neighboring country, and a conspiracy to launder illegal money from various sources, including arms smuggling, and avoid legal taxation on behalf of organized groups of operative working in multiple states. Stop. Huh? It is further alleged that in connection with the matter on 14/9/2022 at about 1900 hours at Naharbari, Dimapur, and 7 Mile, Chumukadima, was searched and recovered about 220 recovered number one, about 220 bags of arecanut from the godowns at 7th mile, Sukhovi Road, Chumukadima, which was owned and managed by Sri Pankaj Kumar Singh. Pankaj Kumar Singh is the applicant.
Pankaj Kumar Mahato, Lordship. Pankaj Kumar Singh, Lordship.
Within
Yes,
brackets.
Pankaj Kumar Singh.
Accused applicant, Staff.
Yes, Lordship.
And
Yes,
number two,
Petitioner, Lordship. Petitioner accused.
petitioner accused, Number two, about 78 bags of arecanut from the godown at Naharbari near Kachari Baptist Church, which was owned by Sri Chunu Mahato. Chunu Mahato is also petitioner.
Yes, Lordship, he is the petitioner in
Okay, Chunu Mahato, okay, stop.
criminal petition 30 of 2023. In item 8, that is. And Pankaj is the petitioner in item 9.
Basing on the above basing on the above FIR, the accused petitioner, the petitioner accused was arrested and the case was registered. Basing on the above FIR, the case was registered being crime PS case number 07/2022 under section 120B 379 and 411 IPC. And the accused and the petitioner accused was arrested. Stop. Para. The case was then investigated into, and after
Lordship, the seized areca nuts, it was also released by the trial court to the petitioners.
released by the trial court in Jima.
Yes, Lordship.
Jima.
Yes. Now, Lordship, if I may be allowed, at page 40 of my petition, I have
page
40 of my criminal petition, Lordship. The annexure 5, it begins from page 38 actually, but the relevant portion appears at page 40, Lordship.
Yes, what is this?
Here, the court has made certain observations, Lordship,
Yes.
while releasing the seized item, Lordship. If I may be allowed to read.
Which one? Para?
The top para, Lordship.
Okay.
Page 40, 40. At the outset, it is alleged that the petitioners do not possess any license and no documentation for transportation and or possession of the seized item. But the records show that the port, Nagaland State Agricultural Produce and Livestock Marketing Port, also known as Nagaland State Agricultural Marketing Port, has issued permit white number so-and-so dated 12/9/2022 to the firm MS Mahato Marketing owned by accused petitioner Junnu Kumar Mahato, permitting the firm to deal in betel nuts, areca nuts, and to transport the said commodity by road or railways from Dimapur to all over India, and the permit was valid till 12/12/2022. It is true that the accused Pankaj Kumar Singh has no permit, but he is in partnership with Junnu Kumar Mahato and has executed a partnership deed, wherein the parties has undertaken to carry out all the activities under the name of MS Mahato Marketing. Now, Lordship, the last paragraph, Lordship. Thus, this is the observation, Lordship. Thus, from the aforesaid materials and the documents placed on record by the accused petitioners, shows a prima facie case that the business of the accused petitioners in the sale and purchase of areca nuts are genuine. It may be noted that the accused persons were apprehended for offences under sections 120p, 379, 411 IPC. However, there is not even an iota of material on record at this stage to show that the seized areca nuts were obtained by the accused petitioners by way of conspiracy or theft, or that the seized areca nuts are stolen properties.
Thereafter, then next para, record was called for. However, on submission of the PP that the case has already been charge sheeted, the LCR was called for. Then earlier it was also LCR. It was not LCR, I think. Okay.
Scanned copy of LCR was called, yes.
Okay. On the submission made by the Lana PP, there is a submission of the Lana PP that the case has already been charge sheeted. The scanned copy of the LCR was called for. Start. And I peruse the same, start, para. After completion of the investigation, the IO of the case has submitted the case above ES case number ES case number 07. What is the number?
Yes,
Seven.
state crime PS case number
Hmm.
07//2022.
22 has been submitted into final report. In its report, the IO has made the following observation. Stop. Following observation within inverted comma. On the complaint received from UBI Makendo Audio IC CID branch Dimapur regarding the suspected smuggling of American nuts and conspiracy to launder illegal money from various sources, including arms smuggling and avoid legal taxation on behalf of organized groups of operative working in multiple states, investigation searched the seized bags of American nuts with HHMD capital and small s in the presence of the independent witnesses, and also requisitioned the bank account statements of the two accused persons, namely Chunu Mahato and Pankaj Kumar, Chunu Mahato, Pankaj Kumar Singh, and Sanjeev Paul. And examine them, but investigation could not find concrete evidence to corroborate the statement of the complaint. Inverted comma close. The IO further remarks that the instant case was investigated upon from various aspects by affording all possible means with the available resources as mentioned in the proceedings paras, and having ascertained that the suspects accused, namely Chunu Mahato and Pankaj Kumar Singh, against whom substantial evidence to charge under section 120B, 379 and 411 IPC could not be established. Stop. And in view of the above, the IO prays for discharge of two accused, namely Chunu Mahato and Pankaj Kumar Singh, from the liability of the said case. Stop. And as a result, the case has been returned into a final report. Stop. Para. In view of the above, this case stands disposed of with the direction to the learned Chief Judicial Magistrate Dimapur
my lord.
to discharge the accused person as per the by following the procedure. No, as per the procedure, within a period of 30 days from today. And probably normally what happens is when the charge case has been filed into its final report, then probably here, of course, the informant is some police. It may not require, but an informant required to be given a notice to file protest petition, if any. So that is why I'm directing to dispose of all within 30 days. So within 30 days, discharge order will be passed.
Lordship, the informant has also been implemented in this present petition, Lordship.
Okay.
As respondent number 2.
Okay, so he will be given
Yes.
an
Lordship,
opportunity. 30
so
days.
if-
Let us say.
Lordship, if powers under 482 can be exercised and if the FIR can be
Not required because
quashed, Lordship.
not required because let this matter be disposed of by the CJM only as per the procedure. Because he has no option but to discharge only.
Yes, of course, of course.
Okay. Within.
Lordship, if I may be allowed to place a citation and if kindly it may be reflected.
Where?
The rest of the
Okay, where?
uh, 2012 5 SCC 242, Lordship.
Para 21.
Yes, Lordship. Commercial business of Harikanath is not a crime, Lordship. So if that can kindly be reflected.
That is where probably they
Yes,
could not
Lordship.
find.
Yes.
And then they suspected something else other than the Arkanat business.
Yes, Lordship. If that can be kindly reflected, Lordship, in my submissions, Lordship, and it can be sent to the trial court as
Para 21.
yes, Lordship. 21.
Not required. I'm directing to discharge only.
In fact, Lordship, in my opinion, Lordship, in my respectful opinion, Lordship, a good law should be laid down in this case because on the ground of suspicion alone, Lordship, the sea of suspicion has no shores, Lordship.
Yes.
So on that alone, without any evidence, Lordship, if citizens are put in custody, Lordship,
That is
and Lordship, these are businessmen, Lordship, their reputation, their good reputation in the society has also suffered greatly, Lordship.
That is true.
And Lordship, Supreme Court has also correctly observed that unmerited criminal prosecution, Lordship, is an infringement on fundamental right of the citizen under Article 21 of the Constitution of India, Lordship. It is reported in 2015 3 SCC 123, Lordship. The relevant paragraph is paragraph 18. If my Lord can.
Here.
No, Lordship.
Okay.
Yes. Unmerited criminal prosecution is an infringement on fundamental rights under Article 21 of the Constitution of India.
Okay, then prior to last one, no. At this stage, Mr. Sanjangar, Prime Counsel for the petitioners, placed citation of the Honorable Supreme Court in Vijay Singh versus State of Uttar Pradesh and others, reported in 2012 5 SCC 242. The relevant paragraph relevant paragraph 21 is quoted below, huh? Para 21, huh? Yes.
Yes, 2-1.
Okay, then thereafter that will come in view of the above, huh? In view of the final report submitted by the eye of the case.
Lordship, in my petition also, Lordship.
With a prayer to discharge the petitioner accused.
Lordship, in my petition, paragraph 10, if that can also be.
Paragraph 10?
Yes, Lordship.
What is there?
That summoning of an accused, Sanjay Ramrao Jawan's case, Lordship. Paragraph 17, summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. Paragraph 10 at page 9.
Para 10?
Yes, Lordship, of my criminal petition, Lordship.
Okay.
If that short paragraph can kindly be reproduced,
Okay.
Lordship.
Then after that again, we also cited the decision in Sanjay Singh, S-A-N-J-A-Y-S-I-H-N.
Yes, Lordship.
Ramrao Chavan versus this para 10, versus Dattatray, D-A-T-T-A-T-R-A-Y, Gulab Rao Phalke, reported in 2015 3 SCC 123, which held that, which held in para 17 that para 17 inverted comma, within inverted comma, summoning of three dot, and then summoning of an accused in a criminal case is a serious matter. Stop. Criminal law cannot be set into motion as a matter of course. Inverted comma close. Okay. Then that will come. In view of the that will come. The final report submitted by the IO of the case with a prayer to discharge the accused his name Pankaj Kumar Singh. In another case, next case, that will be Chunu Mahato. Here Pankaj Kumar Singh. Write both name, Chunu Mahato and Pankaj Kumar Singh, from the liability of this instant case. This case is disposed of with the direction to the Lana Chief Judicial Magistrate, Dimapur, Nagaland, to pass necessary order discharging the accused Chunu Mahato and accused Pankaj Kumar Singh. Leave Chunu Mahato here. In the next case, Chunu Mahato will be there. Pankaj Kumar Singh as per the procedural stuff. The Lana CGM shall pass such order within a period of 45 days from today.
My lord.
Okay, because
My lord.
for giving notice,
My lord.
30 days will require. Okay,
My lord.
45 days from today. With the above this application, this petition stands disposed of. Okay.
Deeply obliged.
Return the LCR, huh? Okay.
Obliged, my lord.
Immediately. Return the LCR immediately. Okay.
For admission, item number 12.
May I please, Your Lordship?
Yes.
Lordship, your pleadings are complete, so I pray that it may come up for admission hearing after 2 weeks.
Okay.
On for number 2.
Okay. But
Upang nanlalangcha.
Land Council for a petition stuff. I've also had Mr. Miss Mere. What is for?
It's number 2.
Two. Okay. Miss Mere Lanet. This is the council appearing on behalf of the state respondent and Mr. Procedural Pote for Lanet. Sorry. For respondent number 2 stuff. The Lanet council for the petition submits that the matter is, sorry, the pleadings are completed and the matter is ready for hearing. Stop. In view of the above, let this, sorry, this petition, and admit this petition, stop, list, and list for hearing after
2 weeks.
2
Lordship.
weeks. Okay.
Obliged, my lord.
Obliged, Lordship.
For orders, item numbers 18 to 29.
May I please, Your Lordship?
Yes.
Lordship, during the last occasion, according to order dated 14/3/2024, we are told to implement UGC as necessary.
Respondent number 12.
Yes.
Okay. Have you?
So we have implemented, we have served Talabana,
Okay.
and then it was found out that that Talabana was missing in the record. So
Missing.
again, we have filed on 25th April 2024.
What file? Affidavit.
Respondent number UGCS respondent number 12.
Okay.
Yes, yes. We have taken step.
Taking a step.
Yes.
Are they appearing on behalf of respondent number 12?
Lordship, notice has been served to them, but it was not reflected.
Not reflected.
Yes. Because after 4/4/2024, there was one time this case was listed, and on that occasion, it was found out that the record
You
which we
filed
have
the
received,
petition for implement petition. Have you filed implement petition also?
we have
Yes, Your Lordship.
yes.
It was allowed.
It was allowed in one.
Okay, order passed, order already passed.
Yes, order
Yes.
passed. UGC has been included in 188. That's
Okay.
respondent number 12. Now the question is whether service of notice on UGC has been completed or not.
Completed.
No, we don't know the
No,
status.
okay. You said it, you have taken
Yes,
steps
we have
upon the
taken
respondent
step.
number 12 also.
Yes, Lordship.
Returned.
So
Service
on the first occasion, we have already served, but the record was found missing. So again, we have
record was found
missing.
missing.
Yes. So we have again given the notice on 24 April 2024 through registry.
So it seems the tracking record shows delivery confirmed, but return service report still awaited.
Okay, Lordship.
Okay. You are for a petitioner?
Yes, Lordship.
Okay, Mr. Learned Counsel for the petitioner. Heard Mr. Learned Counsel for the petitioner. Who submits that? No need to that. Just stop. As per the office note dated 14/5/24, the notice upon the newly implemented respondent number 12 was just a minute, source delivery confirmed. Okay. The sorry, 12 has been delivered and confirmed. However, the service report is still awaited. Stop. So what next then? This was served when it was served?
It was served on 25th April 2024.
Okay. So await or you take fresh steps?
Lordship, that was the second time we have served the notice, so I think there is no need for another third time.
What is the full form of this? UGC, sorry. So it is in where it is? Delhi.
Delhi, yes, Lordship.
So that I think is.
I think we can await for 2 weeks.
Yes, yes. Right. If it is in Delhi. Okay. Okay, Tara. So who appears for the? Okay, Mr. Iralo, you are appearing for, you are for?
Yes, I'm for some of the respondents in all the petitions, so I'll supply the list to the list.
Okay, supply the list. You also?
Lordship, if I may be allowed to make a submission on dated 29/1/24, I made a submission for withdrawal of in respect of 4 respondents in different petitions. However, as per the order dated 29/1/24, it has been reflected that it was ordered to withdraw all our names in all the petitions.
So where it is said?
29/1/24.
29/1/24.
I prayed for withdrawal of 4 respondents in 4 different petitions.
Okay, so you actually want to withdraw from?
In WPC
Where
190,
it is?
in WPC 190, it's respondent number 12.
Just a minute.
And,
Okay, so Shri Jamil and you
Yes.
want to withdraw from which WPC?
In 190, only respondent number 12.
190.
Yes, and
Just a minute. Counsel for the respondent number WPC. Only in that case.
no, there are 4 different
You
cases.
just
Yes.
I think you have to give in writing.
Yes, Lordship.
Want to
I will.
withdraw from which WPC?
In WPC 190, respondent number 12.
198.
190.
190.
Yes.
189.
No,
190.
No, 189, we are not withdrawing.
Oh, you are withdrawing only from 190.
190, respondent 12, 191, also there is 1 respondent, and 194 and
Just a
198.
minute. 190 respondent number
12.
12.
Yes.
Respondent number. Counsel for the respondent number so and so so and so.
And
just a minute. So it is mentioned from 189 also you have withdrawn.
Yes, so this.
It is not correct.
Yes, it is not correct. This order has to be rectified, Lordship. It in respect of only 4 respondents only.
then I think it has to be filed on record. Because there is an order, because from all these 189, 190, 191,
Yes,
and 192 also, and even 194 also.
yes,
From
it was,
all
it
it
was
shows.
withdrawn in all the cases which we were appearing.
You file.
Mm.
That is let us bring it on record. Small affidavit, so for correction, for passing necessary order, because it appears that by this order you have withdrawn from all.
Yes, yes,
Okay.
yes, Lordship.
Okay, and then today's record, huh? So today's you are appearing for home. You also give the list.
Yes, Lordship.
How many petition? 10 total in the list. 12. So you have to give. You also give.
Yes, Lordship.
In which you are appearing. Okay, and then you are also appearing on behalf of.
Lordship, I'm on behalf of respondents represented by Ms. Nuksantila.
Okay, Naksantila. Also in all the
Four WPCs.
Okay, so give
For the state respondents.
state respondents in all. Okay, so there's no problem. But then kindly give. Okay. Okay. Then when do we want? After 2 weeks. Is okay. Then we'll submit that, huh?
Lordship, what if make it 3 weeks, and then if the
3 weeks.
UGC
Okay.
does not appear,
So,
then
and
that will be
here-
the last chance for hearing the.
Miss our submission, Miss so submits that they have withdrawn their wakalat nama from
Only
WPC
in
number.
respect of 4 respondents that you
Huh?
have. Only in respect of 4 respondents we have withdrawn.
Only in respect of.
4 respondents in 4 different petitions.
Okay. Withdrawn and you give that, huh? The withdrawn from which WPC? Okay. And not from WPC. That also you give, huh?
Yes.
From where and from where not?
Yes.
Okay. Stop. Huh? Okay. So as prayed for by the Land Council for the petitioner, list this matter after 3 weeks. 3 weeks. Okay.
For orders, item number 34.
May I please, Your Lordship? I'm appearing for Mr. Supongwati, London Lordship, for the petitioner.
Item
34, Lordship. Lordship, I've been informed that service report is still awaited.
awaited. Yes, yes. You are for petitioner.
Lord, I'm appearing on behalf of the petitioner's counsel, Lord.
Miss, your good name?
Upang Nila Longchan.
Land
Lordship, I'm
Council for the
appearing on
petitioner
behalf.
is present. The office note dated 14/5/2024 reflect that the notice upon the respondent number 1, 2, and 3 no, it only says delivered. Huh? That has been delivered, but the return service is still awaited. Stop in view of the above. As prayed, in view of the above and as prayed, list this matter after 3 weeks. Okay.
Obliged, Lordship.
For orders, item numbers 35 and 36.
My please, Lordship.
Yes.
Lordship, a service of notice is awaited in this case.
Okay. Mr.
Chiang Mai.
Learned counsel for the petitioner is present. So the office, the in view of the office note dated 16/4/2024. Not in view, huh? The office note dated 16/4/2024 reflect that the service of notice upon the respondent number 1 has been caused. Yes. The petitioner has taken steps upon the respondent number 1. However, the service report is still awaited. In view of the above, list this matter after 4 weeks. 4 weeks. In view of the above, and as prayed for by the Nana Council for the petitioner, list this matter after 4 weeks.
Obliged, Lord. For unlisted motion, IAC was 67 of 24.
Unlisted motion.
Yes, Lordship.
So they will take taken up along with the okay.
So my limited prayer, Lordship,
Hmm.
at this stage, Lordship, is only that I may be included, and I, regarding the amendments, Lordship, in the writ petition, since I'm not in receipt of it, Lordship, I'm in the dark, Lordship.
So,
Your Lordship, the hearing has been concluded. Now I will, since the matter is also to be taken up together with this, Your Lordship, I'll just take Your Lordship because he cannot argue beyond what is there on the record. The
now,
record,
now,
yes.
what do you say about the implement?
No, Your Lordship, he is not a necessary party. That is my
Then you file objection.
Then-
File objection.
No, Your Lordship, on the, now the hearing has been completed now. Number one, once the hearing is completed, him coming before this court for implement does not arise. Number two, there is since the matter is already there on record, he cannot, I am not denying that he has not donated the land, Your Lordship. It is an admitted fact. They have donated the land.
Lordship, then
They cannot raise any other points.
In the yes, the writ petition earlier in the earlier writ petition also.
No, I was never met the party.
No,
I was never implemented.
2014.
2007, 2016, 2017, 2022, in all those I was not met the party, which is why I filed separate IAS, Lordship, in all those three petitions.
Your Lordship will see.
And Lordship, my intention is also not to argue against the record, Lordship. What is on the record, I'm not going to argue against it, Lordship. In fact, Lordship.
So, but the whether they are necessary party or not.
No, they are not necessary.
Then you file objection. File objection will.
Your Lordship, the hearing has concluded. I am only to submit my written submission, Your Lordship. If Your Lordship may. Hearing is concluded.
It's part heard.
Since
yeah,
my
it has been part heard, but only for submission of.
Since my Lord will be here for another 2 weeks, 2 to 3 weeks, Lordship, I believe there is ample time for filing objection, Lordship.
We'll take up this matter next week if
Yes.
you can file objection.
Your Lordship, then it may be taken up on Monday or Tuesday. Tuesday will do.
Next week.
Your Lordship, next
My Lord.
Tuesday. Tuesday, I'll file the objection to this.
What is this? 67, 69. What is this? 2? Same.
Yes, Lordship.
Yes, for implement in the three petitions, Your Lordship.
Yes.
Yeah.
Yes, Lordship. For implement in item 37, 38,
Okay.
and item 40,
Okay.
Lordship. In all those 3 petitions, I have not been implemented.
Mr. Santianger. Counsel for the applicant. Also heard Mr. Tongpo Pongener, counsel for the petitioner in 58
2079.
2017, 207, 207, 2016. Oh, in all, sorry.
All the,
Okay,
all the
okay,
petitions.
all, huh?
Yes, all the petitions.
Also had Mr. Convener in, the council for a petitioner in all the petition. So para. This is para. This is an application under Order 1, Rule 10(2) of the Civil Procedure Code 1908 for implement of the applicant in the above referred WPC number all, huh? Separately, in their case, 58. This is 58. 207, 2016, 23, COP 23, 2022, and WPC 88, 2022. Huh?
Thursday, you know, Saturday, Saturday, and Tuesday, Thursday.
On the ground that being the original land or of the suit land, they are the necessary parties. Staff, huh? Issue notice. Returnable by next week. Huh? Since Mr. Pongner, Land Council, for the opposite party petitioner has already accepted notice. No formal notice need be issued. So you have made party to the other also.
Yes, they are pro forma, it should be, Your Lordship, because the government, the state is the respondents in the.
So the whether copy need to serve to them, have you served?
State, Lordship, I have not served to the state. I have served to the petitioner.
The respondent, private respondent also, because private respondent
Yes.
has also been allotted by the government.
Yes.
And then, if it is-
I'll serve.
then you have to serve the copy
serve
to the
Lordship,
private
yes.
respondent also,
Yes,
and
I'll
to the
serve.
government also.
Yes.
Okay. Have you received? No, not yet.
I'll serve within the course of the day.
Okay, the petition, the applicant shall furnish a copy to the, their presence also may be recorded, huh? So Mr. Angami and Miss for the Lana state respondent and Miss. Yes, Apila Sanctum, Lana Council for the private respondent in
6 in WPC.
COP 23 and
WPC 58 of.
358, private respondent, stop. That is in appearance, and in the steps, after Convener accepted notice, thereafter the petition, the applicant shall furnish a requisite copy to the respondent number, the state respondent, and the private respondent. The state respondent you are for Dobasi, no?
Lordship, no, I'm for the private respondent.
Oh, private respondent. Morning, okay, morning. So who will accept notice on behalf of Dobasi?
No, the Tobashi, no.
Yeah, no one appeared.
No one, but the state respondent, he is under the state respondents only.
Okay.
However, Your Lordship, I am not representing that.
Yes.
Achha. Okay. requested copy to the respondent number. Mr. Angami on behalf of the respondent number 1 to 4 and Ms. Sanctama Apila for respondent number 6 in 58 during the course of the days. List is matter next week.
On Thursday, Lordship.
Thursday.
Yes.
Okay.
Then after a week, then Lordship.
After a week. Okay.
10 may be fixed, Your Lordship. 10 may be fixed.
One is to be fixed.
Monday 27th, Your Lordship.
27.
Yes, and then,
Okay.
and in the main.
27. Okay. Main also,
And
along with the main.
In the main also, in the main hearing that
Along
will
with
be
the main.
taken up on 27th.
Okay.
The hearing also, in the main petition.
Okay, along with the main, huh?
Yes.
It will come along with only.
Yes.
Yes.
But then in the main petition, the hearing, since it was.
Okay, in
listed
the,
for-
in the
yes,
main petition, huh?
that order may be reflected.
But Mr. Ponganer, learned counsel for the petitioner. Also had Mr. N. Angami, learned government advocate for the state respondent, and Ms. Apila Sanktam, learned counsel for the respondent number 6. In view of the order passed in IA. No, just list this matter along with the IA, on 27. Okay.
For concluding.
For as a part hard.
Yes.
Okay. As a part hard matter. Okay.
Much obliged.
For hearing item number 41.
Yes.
May I please, Your Lordship? Your
Yes.
Lordship, this matter is listed today for submission of a written argument.
Yes. You have come prepared with the written submission.
Written submission.
Okay. Yes. Have you submitted? What I was planning to do is to, in presence of the land council for the petitioner, I wanted to record the submission of the land council for the parties, actually. So that is why I wanted the party to be present.
Your Lordship, otherwise the written submission.
Yes, that
is
is
a replica of our oral submission itself.
No, that is true, but then at the time of recording,
Yes,
so that I don't make any mistake.
no problem, Your Lordship.
So what I'll do then, your senior is your senior, okay. And then the government is also not their submission.
The state respondents will not be filing a new.
Filing.
application,
Okay.
Relying on the additional affidavit.
Additional affidavit.
And he's on leave today.
Because later on, it was not required also, but then later on, when the things became complicated, then I asked for the written submission.
Yes.
So that is why the submission I want to record in presence of the parties.
Yes.
I'll try because day after tomorrow it is Sunday, Saturday. I'll try out. So in case there is difficulties, what I'll do is I'll present records in presence of the parties.
Yes.
So I'm keeping it on Tuesday.
Okay.
Tuesday. Okay. Just a minute. Mr. Oh, you are for the petitioner.
Mr.
Miss
Lordship,
Imnan Chenla. Imnan Nasenla. How do we pronounce?
Imnasinla.
Imna Senla. Okay, Lana counsel for the petitioner. Also heard Mr. Itibab Pom.
And Muslim Longcomer on behalf of Tibab.
Okay. His name, appear on behalf of Itibab Pom, Lana counsel, Lana government advocate for the state respondent, and Mr. I.M. Chen, Lana counsel for the respondent number 5. Staff. The petitioner, the Lana counsel for the petitioner and the respondent number 5 has submitted their written argument. And the state respondent submits that they will based on the additional affidavit filed by them. Staff, please pray for. So just a minute. List this matter again on Tuesday is for further hearing. As a part hard matter. That's okay. There will not be a further hearing, but then on that day, I'll decide. Okay.
For hearing item number 47.
Kindly this matter may be adjourned for 2 weeks. My senior has personal difficulties today. Kindly this matter may be adjourned for 2 weeks. My senior has difficulties taking up the matter today, so.
No objection, Lordship.
Okay. Mr. Im Chen,
Yes, Lord.
I am Chen, counsel for the respondent number
1, Your Lordship.
1. Praise for listing this matter after
2 weeks, Your Lordship.
2 weeks. Ms. Mikai, counsel for the petitioner has no objection. Is prayed, list this matter after 2 weeks. Okay.
Much obliged.
Much obliged.
For hearing item number 52.
Yes.
May I please, Your Lordship?
Mm.
Your Lordship, here, the petitioner filed WPC number 99 of 2022, praying for granting minimum scale of pay. My Lord, and it was accordingly disposed of on 29th June 2022. My Lord.
This item 52.
Yes, my Lord.
You are for the petitioner.
Yes, my Lord.
Okay. Are we taking up for hearing?
Yes, madam.
Who is for the respondent? Government.
Yes, madam. Moim Chen.
Hmm?
Moim Chen.
Moim Chen.
Yes, madam.
What is this matter about?
My Lord, here the petitioner is praying for minimum scale of pay.
Minimum scale of pay.
Yes, my Lord. As per state of.
Whether this matter has been not mentioned this morning?
No, my Lord.
They must have forgotten then. Someone inform? Because the Moa Im Chen was there in the morning.
Yes, my lord.
Are you also in this one? Item 53 is not connected.
No, my lord.
Okay.
Only for item number 52.
So whether the government has filed affidavit?
Yes, my lord, here the pleadings are completed.
Okay. So in absence of the opposite party, it will be difficult.
Yes, my lord.
What do we do? Next week?
Yes, my lord.
Next week list already prepared, no? No. Miss. you-
Senor.
Kekri.
Senor.
Senor, Land Council for the petitioner is present. No one appears on behalf of the state respondent. In absence of the respondent, the matter stand adjourned. List is after a week. Okay.
Oblige, my lord.
Mr. Moore,
Yes.
we are recording your absent, fixing it after a week.
Oh. Otherwise, Swati's idea, council's idea.
Hmm?
No. Yeah, this was. Okay, your lord. No problem.
Otherwise, she was ready to argue also.
After a week, your lordship.
After a week.
Mm.
Okay, Ms.
Yeah.
Moore is present, huh? Let's pray for by the Land Council. Senior government advocate. Correspondent list is matter after a week. Okay.
Oblige, my lord.
For hearing item number 55.
Maybe his lordship.
Yes.
It's a short matter. The issue involved in this petition, lordship, is whether the transfer of petitioner twice within a period of 1 month is legally sustainable in the eye of law. Lordship knows the scope of judicial review in transfer matter is very limited. The court can interfere in transfer matter only on 3 grounds, lordship.
This was already heard.
No, lordship. No.
Hmm?
Not heard, lordship.
Heard by the,
It's not the part heard matter, lordship.
not the part heard matter.
No.
I thought this was extensively heard and it's a part.
Yes. No, not part heard.
Okay. Justice, I think.
It was heard by Justice Kohima last year,
Okay.
but then it is not get part heard.
So I thought it was a part heard.
No, Lord.
And heard extensively. That's
There is
why
no order as such.
Hmm.
No, Lord.
I thought it will be taken up by the same judge. No? Anyway, so this is transfer matter
Transfer matter, lordship.
of which year?
Transfer order was issued in the year 2022.
2022.
And in view of the interim order passed by the Honorable, which was subsequently made obsolete, lordship.
Okay, there the petitioner is protected by the interim
Yes,
order.
lordship.
Okay. What is the present status now?
As per the initial transfer order, lordship, the place of posting is maintained.
Hmm?
Place of posting is maintained as per the initial transfer order. Lordship facts, the short facts is, lordship, by transfer order dated then 10/2022, altogether 28 professors under higher education department were affected transfer.
Hmm.
The said transfer was initiated by way of a general reshuffle in the department.
By way of?
General reshuffle.
Okay. This is the transfer in the education department,
Yes, lordship, higher education department.
higher education department.
So the petitioner who was working at Wangkao College Mount for more than 13 years. She
More
was
than?
more than 13 years.
Okay.
She was also transferred from Mount College to Timabo. What happened, lordship? Within a period of 1 month, the said transfer order was modified again.
Entire.
In respect of only 9%, lordship.
Okay.
Modified, and the initial transfer of the petitioner from Mon to Dimapur has been cancelled and the petitioner has been again transferred to Tinsang. Has Lordship got it?
Okay.
So agreed by that subsequent transfer order, modification of the initial transfer order, Lordship, the petitioner approached this honorable court, and this honorable court stayed the subsequent transfer order, and the petitioner is still in service in terms of the first
The earlier transfer order.
So that is the short facts of the case.
In terms of the earlier transfer order.
Yes, Lordship.
So from Mon to
Mon to Dimapur.
Dimapur. Now the petitioner is in Dimapur.
Dimapur, Lordship.
Okay.
So Lordship knows the principle of law in transfer matter.
Hmm.
The court can interfere only on three grounds. Number one, if there is malafide. Secondly, violation of rules. Thirdly, if the transfer order is issued by an authority not competent to issue. I'm not in that case, Lordship. However, Lordship, the law says if the transfer order issued in public interest is subsequently modified or cancelled, reason should be given for such modification cancellation after transfer order already issued. Law is very clear, Lordship. And even if this justification is made by way of affidavit, that cannot be accepted. That is the law laid down by this honorable court. Therefore, Lordship, my case is, and the modification cancellation order of the first transfer order, which was issued in public interest, no reason has been assigned by the authorities why the first transfer order has been modified, cancelled. Therefore, Lordship, taking into consideration of all these laws and the principle laid down by this honorable court, interim protection was given, the subsequent transfer impugn order was stayed, and the petitioner is working at Dimapur in terms of the first transfer order. May I take your Lordship attention to the annexures? As a short matter, Lordship.
Yes.
Page 18. This is the general transfer order.
Hmm.
10/2022. Next page, Lordship. Page 19. Serial number 25 is the petitioner. First, second, third column is her place of posting. Has been shown as Wanggo Government College Mont and transferred to Dimapur Government College on the fourth column. And serial number 26 is the bravery respondent number 4. She was transferred from Dimapur Government College to Wangkau Government College.
Serial number 26.
26.
From Dimapur to Mon.
Dimapur to Mon. So by this order, Lordship, altogether 28 professors.
They have been exchanged.
Lordship. It's a general reshuffle, Lordship, in the department, in the entire department. Altogether 28 professors has been affected transfer by this order.
Srichung, Konyak, and then, okay, so they interchanged.
Lordship. Has Lordship got it?
Yes.
So 28 officers were affected transfer, Lordship.
So this 26 is a respondent.
Respondent number 4.
Okay.
So as per the transfer order, Lordship, I've annexed this federal program was also held. And the petitioner has been released from the place of posting, Lordship. And what happened, Lordship? Page 20. Within a period of 1 month, and this is order dated 9 November 2022. 21, page 21 is the type copy is more clear, Lordship. Page 21.
This 18 was issued on 10th.
Yes, first transfer order.
October. Okay. So
and this is 9 November.
9, this is 9 November. Okay.
page 21 is more clear, Lordship.
Yes.
By this order, Lordship, initial transfer order was modified and the petitioner name is at serial number 4.
Hmm. Hmm.
On the third column, Lordship, Virgin Bliss Posting,
Hmm.
Dimapur Government College, that is the petitioner. And it can be transferred to Dimapur, Lordship, Wangkau College, Mon.
Mon going back.
Serial number 4 is the respondent number 4, Lordship.
No, serial number four is respondent number 4.
Yes, Dimapur College. Present post posting has been shown as Dimapur
Serial number
College.
4 is respondent number 4.
Yes, Lordship. See, under remarks column, Lordship.
No, serial number 4 is respondent number 4 by order dated 10/10/22 also from Dimapur to Mon.
Yes, Lordship.
That is same.
No, Lordship.
From Dimapur to Mon.
Yes.
No,
That
by the first order also.
No, Lordship. By first order, Lordship. Let me clarify, Lordship. Respondent number 4 was transferred from Dimapur to Mon.
Dimapur to Mon, yes.
And by the
second order,
he was retained at Dimapur.
Dimapur.
Serial number 4.
Dimapur Government College to. Oh, retain at Dimapur. Okay.
Yes. And serial number 5, Lordship, is the petitioner.
Serial number 5.
It is the petitioner, Lordship. Lordship, may kindly see third column. Present posting, Wangkau College Mon. That is also wrongly shown. To Dimapur College designated.
No, by then she already joined.
No, Lordship. And Lordship.
By that time, she was yet to join Mon.
Yes, to join.
Sorry, yet to join Dimapur.
Dimapur, Lordship. Because release order was not issued despite repeated requests by the petitioner.
No, just a minute. Then she is from then she was shown from Mon.
Yes. Lordship, may kindly see the remarks column. Right hand side. Transfer to Saojang College, Chuisang. A case, I'm not concerned about that. By this.
To Dimapur College. Just a minute. So the fourth column is Wangchu College Mon to Dimapur Government College designated.
Yes.
From Mon to Dimapur.
Yes.
Okay, then
transfer to Saojang College. This initiative was taken within a period of 29 days, Lordship.
Transfer to
Saojang College,
Tuensang.
So, Lordship is clear?
Yes.
No reason, nothing has been mentioned in this order. Why the first transfer order which was issued in public interest was modified, cancelled by this imbued order, Lordship. No reason, Lordship. Why I am saying no reason, Lordship? The law laid on by this Honorable Court is that if the transfer order issued in public interest is modified or cancelled by a subsequent order, reason should be mentioned in the order, Lordship. That is the prevailing law.
Yes.
Am I clear, Lordship?
Yes.
So that is the short facts of the case. No reason, nothing. However, Lordship, by filing affidavit and opposition by the state respondent as well as the private respondent number 4, Lordship, he come with a plea that this impugned subsequent transfer order whereby the respondent number 4 was written at Dimapur, has been done in view of the health condition of her son. That is the reason. On that ground, Lordship, I don't have any submission.
Maybe in the application filed by the
Lordship,
respondent number 4.
I have nothing,
Based on that.
I have nothing to submit.
But
on
then
that.
that is not reflected in the order.
Yes, I have nothing to submit with regard to the physical condition of the son of the respondent number 4. Whether she submitted application or not, I have nothing to submit.
Okay.
But what the law says, Lordship, law says reasons should be specified in the order for such modification or cancellation. That is the law. My case is based on that only, Lordship. As I was submitting, Lordship, the principle of law and transfer is very well established.
You have cited citation. You have
I've
given
given
the citation
citation.
also.
Yes.
Okay.
It is not a general transfer, Lordship.
Hmm.
I'm concerned about the modification cancellation.
Mhm.
So far as the general principle of law with regard to transfer is concerned, Lordship is well aware.
Okay.
So first decision, Lordship, 1997 1 GLD.
You have a copy?
Nineteen 1 GLD, page 140. I'll refer to three paragraphs, Lordship.
Para number?
Paragraph 3, 4, Lordship, married paragraph 3.
Paragraph 3, 4.
4, 5, 6, 7, 8, and 10.
No,
Short
then
paragraphs.
entire paragraph.
Married, Lordship?
Yes.
Paragraph 3. This case has jagged history and factual metrics may be briefly stated. By an order dated 17 October 1995, the government of Nagaland Finance Department transferred as many as 3 officers, including third respondent and public interest. In the aforesaid order, the third respondent, Assistant Commissioner of Taxes, Dimapur Zone. Dimapur was transferred and posted to Moksong Zone. This order was modified, Lordship, by another dated 5th December 1995, giving an advance of the transfer of third respondents to Moksong. The order dated 5/12/1995, modifying the order dated 17/10/1995, has an important sparing and it is extracted. I'm not reading the order, Lordship. Paragraph 4. The opposite order dated 5 December 1995 has been excelled by one of the affected government servant in civil roll number 162 BR 1995. This court on 12/12/1995 issued roll and suspended the modification order dated 5/12/1995 in terms of the following. This court has held repeatedly that for cancellation, modification, or give in advance of the transfer order passed in public interest must be supported in sufficient reasons. From the impugned order dated 5/12/1995, it is clearly appears no reason whatsoever has been assigned necessitating the passing of the modification order. Paragraph 5. The present impugned order dated 14/2/1996, which has been sealed and the writ petition and has been passed again in the supersession of order dated 5/12/1995. The impugned order dated 14/2/1996 reads, I'm not reading, Lordship, that is the modification order. Paragraph 6. From the facts as allotted above, it clearly shows that within the span of almost 4 months, as many as 3 transfer order has been passed in respect of third respondent without assigning any reason. Therefore, it cannot be said to be in public interest. Paragraph 7. From the impugned order dated 5 December 1995, which has been excelled in another civil roll number 2 and the order dated 14/2/1996, which has been excelled in this civil roll, it is clearly appears that no reason has been assigned necessitating the modification or supersession of the transfer order dated 17 October 1995, passed in public interest. Paragraph 8. This court and a Gadena of decision has held that for cancellation, modification, or giving in abeyance of the transfer order passed in public interest must be supported with sufficient reasons necessitating for passing such order. The view taken by this court has reasonable behind it. Once the transfer order is made in public, and there is court normally do not interpret unless the order is passed with malafide or against the custodial rules. The only way open to the equipped government servant is to file a representation before the competent authority to redress his grievances. But this court insists that for cancellation, modification, or giving in, it is an abuse of such order must be supported with sufficient reason. Because transfer of officers are always made in public interest, and after elaborate exercise as to who should be transferred where in the exegesis of administration. While processing the transfer order, various factors are taken into consideration. One such factor being the duration of the stationing of the one officer at a particular station for a long time. If an officer is posted at a particular station for a long time, no doubt that he also acquired a considerable knowledge about the administration of the area. But at the same time, he also often established vested interest in the area because of his long association, and to avoid such eventualities, timely posting is always called for. Therefore, if the transfer order made in public interest is allowed to be taken away by a grave order, modifying, cancelling, or giving an abeyance of the transfer order without assigning any reason, it ceases to be in public interest. Therefore, it must be held that the order has been passed at the whims and caprice of the authorities exercising the power. Public interest would not be allowed to sacrifice at the elder of the whims and caprice of the authorities exercising the power. It must be grasped that the public authority possesses power in use for the public interest. Last paragraph 10, Lordship. As already said, the Imbued Order dated 14/2/1996 and the Imbued Order dated 5/12/1995 as ordered above lack reasons, Lordship. Lack reasons. No reason was there in that cancellation modification order. Let alone sufficient reason, and therefore it cannot stand the scrutiny of the law. The Imbued Order dated 14/2/1996 is accordingly quashed and set aside. Same case, Lordship. Same subject matter. Next, Lordship, 2013. Five GLD 487. I'll refer only 4 paragraphs, Lordship. Paragraph 2, 7, 21, and 22. This is also case from our Lordship. May I read, Lordship, paragraph 2?
Yes.
Brief facts of the case arising from the writ petition. The affidavit in opposition, affidavit in reply, and the additional affidavit filed by the petitioner and the respondents are as follows. The writ petitioner, Dr. Tubin Bakra, was originally working as Suyesu at Alo, wherefrom he was transferred to Suyesu as Temu by order dated 7/10/2010. After completion of more than 2 years and a half, has been ordered to transferred by order dated 5/4/2013 from Doborichu to Suyesu in the East Siang district in the same capacity. By the same order issued by the Commissioner Health, Government of Arunachal Pradesh, one Dr. Suyesu Temu Sabao has been transferred to the resultant vacancy of Suyesu at Doborichu. Due to the aforesaid transfer of the petitioner, the boss of Suyesu at Sabra, Sipa, in turn has been ordered to be filled up by one Dr. Nekigi, who was the Suyesu Doborichu. Thus, the order dated 5/4/2013 involves 5 places and transfer of 5 persons. By the said order, the petitioner has been directed to report for training at Suyesu, and the respondent number 3 herein, who is in charge of the DMO at that place, has been directed to hand over the charges to the regular DMO, namely the petitioner herein. It may be mentioned herein that the respondent number 3 was originally posted at Suyesu and Bashikat itself since 2005, and by order dated 9/8/2012. Suyesu, he was posted as IC DMO at the same place till DBC or posting of regular DMO. This order reveals that the respondent number 3, Dr. Suinso, never appointed as regular DMO at Basikat, where the petitioner has been transferred by order dated 5/4/2013, annexure Suinso to the writ petition. The writ petitioner was released from Laboratory on 9/4/2013, enabling him to join his new place of posting at Basikat and Deraban. He reported for training to the Deputy Commissioner on 11/4/2023. The said training report appears to have been received by the confidential assistant to the Deputy Commissioner on the same day. Subsequently, communication dated 24/5/13, which shall refer to later on, the Secretary to Government of Arunachal Pradesh and the Department of Health and Family Welfare indicates that Deputy Commissioner by wireless WD message sent on the same day had apprised the Secretary so as to joining of the petitioner, and thus it is discernible from the materials on record that the Deputy Commissioner himself was in the active participation of the whole affairs. The petitioner has claimed that having reported for joining so being the head of the civil administration at Basikat, he convicted the respondent number 3 for taking over the charge pursuant to order dated 5/4/2013. But he, in turn, asked the petitioner to wait for some time so that he can make necessary arrangement. But finally, he went on delaying and did not hand over the charge. Rather, finally disclosed on 24/4/2013 that the appropriate authority has already passed an order on 11/4/2013, allowing his retention at Basikat. Lordship, that is the facts. Paragraph 7, Lordship. Paragraph 7, page 490. Here, Lordship, why I'm referring this, the earlier case was referred to in this judgment, Lordship. Paragraphs I'm not reading. Paragraph 21, Lordship. The important part, Lordship. Paragraph 21, page 493.
Yes.
This is the finding, Lordship. I find sufficient force in the submission of the learned counsel for the petitioner in this case. Having issued a transfer order on 5/4/2013 in public interest, the government fell in error in modifying the same after merely a week, and that too at the asking of the external authority without there being any access to the public interest. It is not conceivable under the existing cabinet setup of executive as to how someone who has no responsibility in a given department can book nose, and the Honorable Chief Minister also obliged to such requests. Above all, secretaries and commissioners of the government at various departments are aware that the day-to-day functioning of the respective department. So the view based on the materials and records cannot be in any man be preferred to be the personal likes or dislikes of political personalities who, in view of the opposite politics, may have very compulsions. Besides this court, in the case of this, the earlier first case was referred here, Lordship. So I'm not referring to that, Lordship. Paragraph 22. In the result, the writ petition is allowed. The order dated 11/4/2013, allowing respondent number 3 to remain at Basikat as demo is set aside. It expected that the government shall take, so Lordship, the subsequent modification order, which was issued without any reason, was set aside by the Supreme Court. Last judgment, Lordship. 2021 5 GLD 652. Paragraph 1, 2, 3, 4, 12, and 13. May I read, Lordship?
Yes.
Paragraph 2. With this backdrop, let us now come to the facts of the case in hand. Paragraph 3. The petitioner has put to challenge orders of transfer dated 25/8/2020 as well as 22/9/2020 issued by the authorities of the State Bank of India Bank and for direction to allow him to join at Dadara Kamruk R as per order dated 28/5/2020 or Raha as per order dated 18/9/2020. The petitioner is also agreeable that alternatively he may be posted in any place near Gauhati so that he can take proper care of his ailing mother, who also suffers from a disability. Paragraph 4. The petitioner is a deputy manager and was posted at Naugang, main branch of the bank, on August 2028. While serving there, an office order dated 28/5/2022 was issued, promoting the petitioner to the rank of assistant branch manager and transfer him to Dadara branch. However, under alleged ground of paucity of officers, the petitioner was not released from the similar case, Lordship, Naupang branch. However, within the short span, another order dated 25/8/2022 was issued, modifying the earlier order of transfer and transferring the petitioner to Zero in the state of Arunachal Pradesh. The petitioner immediately submitted a representation dated 26/8/2020 for modification of the transfer order, followed by filing a writ petition before this court, which was registered in Liberal Suiso. Incidentally, the bank authorities also acted in the meantime, and by order dated 18/9/2020 modified the imbued order dated 25/8/2020 and posted the petitioner at Raha branch as the branch manager. Under such circumstances, the earlier writ petition, namely WBC Suinso, was withdrawn with a liberty to file by order dated Suinso. However, even before joining the new place of posting, Raha, the bank authorities issued another order of transfer dated 22/9/2020, whereby the earlier order dated 18/9/2020 was cancelled and the petitioner was again posted at Zero in the state of Arunachal Pradesh. The petitioner had again approached the authorities by submitting two representations whereby the ill health and disability of his aged mother were highlighted. As no requisite action was sent to be taken, the present petition was filed, and this court by order dated while issuing notice of motion came to a preliminary finding of arbitrariness and unreasonableness on the part of the authorities, and accordingly the imbued order dated 22/9 was stayed until further orders. It appears that the bank authorities had filed so for modification of the order dated so. However, the said application was dismissed with the observation that no interference of the stay order was called for, and also further observed that any modification or alteration of the stay order or rendered the writ petition infractious. Paragraph 12, Lordship. Paragraph 12, next page. Let us first deal with the first facts of the case sequence wise. The petitioner who was at Naugang was transferred to Suinso by order dated 28/5/1920. However, the petitioner was not released from Naugang, and by second order dated Suinso, the petitioner was transferred from Naugang to Zero branch. The petitioner was made to understand that he was not released due to paucity of officers, which he was otherwise ready and willing to join. It appears that acting under representation of the petitioner against the move to transfer him from Zero, the petitioner was transferred to Raha, a branch as branch manager by order dated so. The fact of filing WBC number so against the order dated 25/8/2020 in the meantime cannot be totally ignored, including the action of his withdrawal on 21/9/2020 in view of the order dated 18/9/2020. Even assuming that the respondent bank was not aware about the filing of the earlier writ petition, the bank has do independently and fully justify the order dated 22/9/2020, but just after a day of withdrawal of the writ petition, whereby the petitioner was again been transferred to 0. 2. In paragraph 13 of the affidavit in opposition, the reason for again this important lordship, transferring the petitioner to 0 has been sought to be justified. Such justification in the opinion of the court appears to be perfunctory and irrelevant. So far as the respondent number 5 is concerned, it is been submitted that he has already retired on so and the vacancy arising on the transfer from 0 cannot be said to be necessary to be filled up by the petitioner only. The explanation regarding the respondent number 7 at Raha as his role and campaign period of undertakes from 10/3/2020 to 23/2020 was found admirable and affecting recovery, and so far as the handling of the financing fisheries are concerned, cannot be accepted as a sufficient ground for impugned action. If the justification is to be accepted, then the respondent number 7 can never be transferred from Raha in the entire life. It has also been argued that we have of the bank that from 2011 onwards, the petitioner has been posted in and around Gauhati. It is sent from 2011 at Gauhati. The petitioner was posted at Gauhati, Sonapur, and lastly at Nagaon, Gauhati. Sonapur and Nagaon are independent places of posting which were issued by the bank on their own volition. 2. It appears that the order dated 18/9/2020, by which the petitioner was transferred to Raha, was issued after considering the representation of the petitioner and by giving the benefits of doubt that the bank was not aware of filing WBC number so. The said order was an independent action of the bank without any direction of this court, as a result of which the writ petition was withdrawn on so day. In that view of the matter, the impugned order dated 22/9/2020 issued just after 4 days doesn't appear to be justified at all. 2. It is the prerogative of the respondent bank to post any officer at any place of posting, the bank coming within the definition of any other authority under Article 12 of the Constitution of India. It is modern duty to act fairly, reasonably, and transparent manner. This is very important, Lordship. 2. In the affidavit in opposition, dated 18/11/2020, certain explanations are sought to be given in view of the absence of such justification or even a hint thereof in the impugned order dated 22/9/2020, the same cannot be accepted by this court. The Honorable Supreme Court and Cadena of Decision has settled the law in this regard. Reference case of Mohendra Singh case, Lordship. That's a well-known judgment, Lordship. Honorable Supreme Court, after quoting with approval, landmark case of so and so. This is important, Lordship. I'm reading. Paragraph 8. The second equally relevant matter is that when a statutory functionary makes an order based otherwise, the order bed in the beginning me by the time it comes to the court on account of a challenge get validated by additional grounds later brought out. We may have true attention to the observation of so. So next, Lordship, paragraph 13. Even otherwise, as discussed above, the justification put forth in paragraph 13 of the affidavit in opposition appears to be perfunctory and superficial. 2. So learned counsel for the bank may be correct in containing that transfer is an incidence of service, and the impugned order has been issued for exegesis. the same has to be tested under the scanner of Article 14 of the Constitution of India by balancing the fundamental rights of the petitioner to be treated fairly and transparently. Therefore, without even going to the aspect of issue of disability of the mother of the petitioner vis-a-vis the circular so, this court is of the view that a case for indifference is made out. Accordingly, the writ petition is allowed by setting aside and quashing the ambient so, by which the petitioner was sought to be transferred to zero. Here, Lordship, this judgment is very much applicable because by filing affidavit in opposition by the respondents, they brought with a new plea that the subsequent notification order was issued because of the fact that her son is a disabled son, suffering from some ailments. That is the specific case of the respondents. However, Lordship, in view of the law laid down by this court, as well as in Mohinder Singh case, Lordship, it is well settled. The order cannot be modified in such a manner by bringing new facts by way of an affidavit, Lordship. Therefore, Lordship, the impugned order by which the earlier transfer order, which was issued in public interest, was modified, is prima facie illegal and contrary to the law laid down by the Honorable Court, which are referred to Lordship. Therefore, Lordship, the impugned transfer order in 9/11/2022 is liable to be set in quash. Lordship, in order to save time, I'm not referring to the affidavit filed by the respondent because, Lordship, the only contention in the affidavit in opposition is the ground of disability of her son. That is the only ground. And I've submitted a Lordship, so far as the general principle of law and transfer matter is concerned, it is well settled. Unless there is malafide, violation of rules, or the transfer order is issued by an authority not competent to issue, the court cannot interfere in transfer order. But my case in hand is different from that principle, Lordship. It's a case of modification. Therefore, Lordship, the impugned order dated 9/11/2022 is liable to be set in quash.
Okay.
I conclude my submission, subject to reply.
Yes. Yes, state.
Yes, bless your Lordship. Your Lordship, my friend has stated about the settled principle of law in regard to transfer. I agree to that. Now, the points he has given was malafideness in the order, violation of statutory rules in the order, in protesting the order, transfer order passed by an authority who is not competent. So if that is met out, then in that case, then this honorable court can interfere. Now, let me come to the transfer order passed by an authority who is not competent. Both the orders, Your Lordship, that is 10/10/2022 and notification 9/11/2022 were made under the name of the governor of the state, who is the executive lead of the state. So the question of transfer order produced by an incompetent authority does not arise.
This order is
both the orders are passed under the name of the governor.
Name of the governor, yes.
Governor, yes.
Okay.
You'll find in page 18 the first order. That is 10 October 2022, page 18 of the writ petition. And then notification order, that is 9 November 2023, you'll find Your Lordship will find in page 20.
Yes.
So both the orders general transfer order as well as the modification order was issued in the name of the governor. Yes. So the question of incompetency of the authority does not arise. Now, Your Lordship, one point. It is a settled position in service jurisprudence in regard to the transfer. Transfer and posting of an employer, Your Lordship,
Yes.
by the employer is incidental to the employment, Your Lordship.
Yes.
So it is not the wishes of the employer, because, Your Lordship, the employer always make the transfer and posting in the best interests of the institution where the employee is serving. So it is a prerogative of the employer to post where to, whom to where. So insofar as these two principles has been concerned, Your Lordship, violation of statutory rules and then transfer order passed by an authority who is not competent does not arise. My learned friend, so the only question remains is mala-fide. So it is for my learned friend to make out what is whether there is a mala-fide in the order or not, and in the modification order. The only question remains is mala-fide. Let me answer Your Lordship why the modification order was not mala-fide. Your Lordship, may please come to page 3, paragraph 5 of this state counter. Page 3, paragraph 5 of the state counter. Counter file on behalf of state respondents 1, 2, and 3. Paragraph 5, page 3. May I read, Your Lordship?
Yes.
That with regard to the amendments made in paragraph 6 of the writ petition, the answering deponent state herein that the initial transfer order dated 10/10/2022 was modified by another order 9/11/2022 in respect of 9 officers. In respect of respondent number 4, the answering respondents received a forwarding letter from the principal, Dimapur Government College, Dimapur, on 14/10/2022 for retention of service of the respondent number 4 and Dimapur Government College, Dimapur, on humanitarian grounds. The authorities accordingly examined the medical report submitted by the respondent number 4 in respect of her child, and it was found to be genuine, as her child, aged about 3 years old, is a patient of Down syndrome and congenital heart defect, arterial septal defect, who is in constant need of medical supervision and care, which is available only in Dimapur, Your Lordship. Which is available only in Dimapur, not in Mon, Your Lordship. As such, answering deponent considered the request of the respondent number 4 and retain her service in Dimapur Government College on humanitarian ground, taking into consideration of office memorandum dated 8/10/2018, which provides that exemption from the routine exercise of transportation. Your Lordship, that notification office memorandum you will find. That office memorandum you will find in page 14, Your Lordship. This is a office memorandum, which has been produced by Ministry of Personnel, Public Grievance and Pensions, Department of Personnel and Training, Government of India. So Lordship,
What the memorandum says?
may I read your Lordship?
Yeah, the relevant portion.
Office memorandum. Subject exemption from routine exercise of transfer, rotational transfer. Considering the transfer of a common employee who serves as the main caregiver of persons with disability would have a bearing on the systematic rehabilitation of persons with disabilities. The government issued OM of even number dated 6 June 2014 to exempt such employee from routine exercise of transfer, rotational transfer, subject to administrative constraints. Number 2, the scope of this disability initially covered blindness or low vision, hearing impairment, locomotor disability or cerebral palsy, leprosy, cure, mental retardation, mental illness, and multiple disabilities, which subsequently, white OMs of even number dated so and so, was further extended to include autism, thalassemia, and hemophilia.
Okay, so the state received an representation from the respondent.
Your Lordship.
The state, the authority has received a representation from the respondent, number 4.
Yes.
Have you
Lordship, you will find in page 9. The representation made by the application, made by the respondent number 4, you will find in page 9.
Yes.
May I read, Your Lordship?
Yes.
To the Secretary Higher Education, Nagaland Kohima, through proper channel, subject prayer for retention and Dimapur Government College on humanitarian grounds. Madam, may I humbly say that few words for your kind action and consideration, please. That, Madam, as per the official order, such and so, I have been transferred to Wangkau College, Moon. At this juncture, I would like to mention that my child, 73 years, has a condition called Down syndrome. As a result, he needs constant medical treatment, physiotherapy, occupational therapy, and so on. He has also congenital heart defect, arterial septal defect, and is common to people with Down syndromes, for which he needs constant medical supervision and care, which is not available in Mon Town or Mon District. Therefore, Madam, I would be very grateful if my case is considered exceptional to the
Whether the record was called for? No. Records of the file.
Record is available also there in gross all the documents.
Okay.
So
we,
the documents based on the available documents, because representation has been annexed by the respondent as well as by the respondent also. So we considered because also annexed. Representation was submitted on 12/10/2022. So we considered this representation. And accordingly, modification transfer order 9 November 2022 was.
So modification here for 9
November
2022. Nine officers.
Yes.
Modification, and not only with the in respect of 4 and respondent number 4 and the petitioner, but there are 7 others.
Yes.
Okay? Total 9.
Yes. 8 others.
Where is the other? These other persons have also filed a writ petition.
No,
challenging.
no, others has not filed. Only
only the present petitioner.
Only the petitioner has filed.
Okay. Now, where is the respondent number 4 now? Respondent number 4 is.
As with the subsequent modification order, she's supposed to be posted in Wangkau Mount, Lordship. However, there's a latest development, Lordship. It is a temporary arrangement, Lordship.
Okay.
She is now posted in Dimapur, Lordship. Again, it's a vacant post due to the vacancy due to study leave taken by one of the professors.
Okay.
Now
the respondent number 4 is at Dimapur government.
Dimapur only?
Yes, Lord.
Okay,
This is order dated 29 of February 2024. By this
Okay.
order, I was brought back to Dimapur, Lordship. But
Okay.
this is just a temporary arrangement, Lordship. My place of posting as per the order,
Mount.
it has to be Mount. The first order has to be Mount, whereas the modification I was transferred back to retain to Dimapur. Lordship. But there's a
but then
clear
because
order.
of the stay, so she had to join, he or she?
She
had to join to Mon.
Yes, Lord.
Okay, so now she has come back
Yes, Lord.
by this temporary arrangement.
Yes, Lord.
That's well and good, Lordship.
That is good only. Because
Because the issue is legality of the modification of the task.
uh-huh.
If she is accommodated Dimapur or Kohima, I have no objection.
Hmm.
But I should not be affected by the modification. That's
Because the what you justify,
Your
or the
Lordship.
order is okay, but then you
Modification
you have-
order was stayed by this honorable court.
Yes.
So now,
Hmm.
the petitioner is already in Dimapur, right?
yes.
Because of the stay of the modification order, 9th November 2022.
Hmm.
Because this honorable court has stayed that modification order. So because of the stay, petitioner is in Dimapur. And meanwhile, by this order, your lordship, 27 February 2024, the private respondent is in serial number 5, your lordship. So she has been attached due to the study leave of one professor.
Study leave maybe generally for 2 years.
No, maybe even.
And in the meantime, what is the tenure for the transfer policy?
There is no time limit, Lordship.
No time limit.
Yes.
So
Because
like
I
say
was
in
transferred
Arunachal
after
Pradesh,
serving-
3 years. So there is no time limit here.
There's no time limit.
I was transferred after serving for 13 years in Mon, Lordship.
Okay.
And it is only a temporary arrangement, Lordship.
Mm-hmm.
Because of the vacancy caused by one professor on study leave. Maybe it will take another 3-4 years because maybe PhD course.
Hmm.
Once it is a PhD course, it takes minimum 3 years.
In the meantime, after the tenure is over, probably with the justification, the government can always issue. But then without justification, without giving any reason, it's very difficult again. So within a short period, and then one person going to one station, and then just immediately after some time, without giving any reason, transfer, and then going. So this actually the system or intervention by means the arbitrary transfer of by the government is actually the court also deprecated. So this the court also doesn't allow. So now what do we do? This is temporary arrangement. Probably it will last for another say 3-4 years.
I cannot say on that, Lordship.
Hmm.
All should be.
But then per se, prima facie, of course, this.
It is just to bring it to the record of this honorable court.
Right,
The
right.
main issue is pertaining to the first 2 orders, Lordship. The 1st October as well as the subsequent order, Lordship.
You have anything to submit in that?
Of course, Lordship.
Okay. Have you completed anything?
I have
anything?
completed. I have
Okay. So
Because
you,
your
what
lordship
you want? What any? What more you want to submit?
Lordship, I'll be relying more on the question of law, Lordship.
Yes.
Because my retention order has been challenged, put under challenge in this repetition, Lordship.
Yes.
And if that is interfered, Lordship, the subsequent order, the modification order, where I was retained in Dimapur College, Lordship, if that is interfered, Lordship, then, Lordship, that will definitely affect my interest, Lordship. Lordship knows if I may be allowed to make my submissions, Lordship, I'll make it very short, Lordship.
Yes.
And I'll be making my submissions only on very limited question of law, as well as just on 1 or 2 aspects of the facts, Lordship.
Yes.
Lordship, this is a very exceptional case or an extraordinary case, Lordship, where that modification order was effected, Lordship, only on one ground, Lordship. And that ground is only on the question of medical ground, Lordship. The first order was passed on 10/10/2022. That was the first transfer order, Lordship. The first transfer order. And by that first transfer order, I was transferred from Dimapur to Mon, Lordship. Now, immediately after 2 days, Lordship, I have submitted a representation expressing about the difficulties, Lordship, more particularly about the medical condition of my son, Lordship.
Yes.
Now, on that ground, the government, the concerned college, they forwarded my representation to the government, and government took a decision. Now that subsequently the modification order was out by an order dated 9/11/2022. I'm referring to the two orders which
Yes,
which is enclosed in the repetition, Lordship.
Whether you annexed the forwarding letter?
Yes, Lordship, it is part of the record filed by the government, Lordship. Lordship will find it government's affidavit, Lordship. Page 8, Annexure A, Lordship. This is the forwarding letter, forwarding the representation submitted by respondent number 4 to the government. Thereupon, after examining my representation, the government took a decision, and the decision came out by way of this notification dated 9/11/2022, Lordship. The other 5 candidates who were also affected by the modification may be for some other reasons, Lordship. Of course, I also agree with the fact that no reasons were stated in the general comment order, Lordship, where the modification was affected, Lordship. But my reason is, since it is very apparent from the record that my representation was considered on the question of medical ground.
Okay.
Now, Lordship, coming to the question of law, Lordship. The senior counsel for the petition has clearly stated that the question of transfer can be indiffered only on 3 grounds. In fact, a judicial review of this honorable court, Lordship, only on 3 grounds. First is malified intention or malified action. Second is if there's any violation of the mandatory statutory rule. And third is if the order is passed by any authority who is not competent to pass such orders. In the entire bleedings, Lordship, there's no mention that there is violation of rules. There's only an averment made in one specific paragraph that there is malified intention. But just because there is a whisper of malified intention without any cogent materials should not suffice for intervention of this honorable court. Thirdly, Lordship, no allegation, no averment stating that these orders were passed by an authority who is not competent. Only on these 3 grounds, Lordship. Now, my respectful submission before this honorable court is that there is no violation of any of these 3 grounds. And Lordship also knows very well, with regard to transfer, it is purely the prerogative of the authorities concerned. And this honorable court has limited say on the transfer, unless these 3 grounds are being satisfied. My respectful submission is that there is no malified intention. There is no violation of statutory rules or the authority who Firstly, with regard to the celebrated judgment pertaining to the prerogative of the authorities concerned, on which grounds the authorities or this honorable court can interfere with regard to transfer. Division bench of the Honorable Apex Court, 2004, volume 11, SCC 402. 2004, 402, Lordship.
Okay.
402. 2004, 11, SCC 402, Lordship. I'll rely only on 2 paragraphs, paragraph 7 and paragraph 8. Lordship will find paragraph 7 at page 406, Lordship.
Yes.
If your Lordship got it?
Yes.
May I read it? Paragraph 7, Lordship.
Yes.
It is too late in the day for any government servant to contend that once appointed or posted in a particular place or position, he should continue in such place or position as long as he desires. Transfer of an employee is not only an incident inherent in the terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contrary in the law governing or conditions of service. Unless this is important logic, the order of transfer is shown to be an outcome of mala-fight, exercise of power, or violative of any statutory provision, or passed by an authority not competent to do so. These are the only three grounds where this honorable court can interfere.
Yes.
An order of transfer cannot lightly be interfered with as a matter of course or routine for any or every type of grievance sought to be made. And they have also raised a grievance stating that there is no reason assigned in the transfer or modification order. Even administrative guidelines for regulating transfers or containing transfer policies at best may afford an opportunity to the officer or containing transfer policies or servant concerned to approach their higher authorities for redress, but cannot have the consequence of depriving or denying the competent authority to transfer a particular officer servant to any place in public interest, and as it is found necessitated by exigency of service as long as the official status is not affected adversely and there is no infraction of any career prospects such as seniority, scale of pay, and secured emoluments. My respectful submission before this honorable court, Lord Chief. At best, he can approach the authorities concerned, addressing his grievances in the first place, but not before this honorable court for interference. Because my respectful submission is that the petitioner, he has failed to make out a case for interference of this honorable court, because he could not make out a case that there is violative on any of those three grounds. This court has often reiterated that the order of transfer made even in transgression of administrative guidelines cannot also be interfered with, as they do not confer any legally enforceable rights unless as notice supra shown to be vitiated by mala-fide or is made in violation of any statutory provision. In fact, Lord Chief, as going by the submission advanced by my learned senior counsel for the petitioner, no mala-fide intention has been raised. No violation of the statutory provision of any rules or law, or no intention or no contention has been advanced that the order was passed by an authority who is not competent. Para 8, Lordship.
Yes.
A challenge to an order of transfer should normally be eschewed and should not be continuanced by the courts or tribunals as though they are appellate authorities over such orders, which would assist the niceties of the administrative needs and requirements of the situation concerned. Therefore, the reason that courts or tribunals cannot substitute their own decisions in the matter of transfer for that of competent authorities of the state, and even allegations of mala-fides, it is also important, when made must be such as to inspire confidence in the court, or are based on concrete materials and ought not to be entertained on the mere making of it, or on consideration born out of conjectures or surmises, and except for strong and convincing reasons, no interference could ordinarily be made for an order of transfer. This is very clear, explicitly clear logic. My respectful submission before this noble court. The modification was effected only on the representation submitted by respondent number 4 and for no other reasons, Lordship. And even my grounds for seeking that retention at Dimapur, Lordship, that is even on the medical grounds, which has been accepted by the authorities concerned, and have produced all the relevant materials before the concerned authorities, before they arrive to a conclusion, a decision, Lordship. May I continue after break?
Okay. So any more?
Lordship, I have some authorities to rely upon, Lordship.
Okay.
On 3 question of law, Lordship. Or should I continue, Lordship?
How long it will take?
I may take around 20 minutes, Lordship, 20 to 30 minutes.
20 minutes?
Yes, Lordship.
Or what do you say?
It's up to the court, Lordship.
Okay. So just finish it.
Lordship.
It shouldn't take much time, I think.
I'm obliged.
Okay.
Obliged.
Yes.
And make an interview to reduce the time, Lordship.
Yes.
Lordship, coming to the public interest and administrative reasons, Lordship. 1991 Supply Volume 2, 659, Lordship. Public interest and administrative reasons, Lordship. 1991 Supply Volume 2, 695, SSC, Lordship.
695,
Lordship, 695. Paragraph 3 and 4, Lordship.
Six five.
659.
Paragraph
3, 4, Lordship. For clarity, Lordship, I'll be referring to the facts at paragraph 3, Lordship. After hearing learned counsel for the parties and having considered the facts and circumstances of the case, we are of the opinion that the High Court committed serious error in interfering with the transfer orders of primary school teachers. The High Court held that District Education Establishment Committee had no jurisdiction to transfer the primary school teachers on their request. We find no justification for this conclusion. There's no dispute that the District Education Establishment Committee is competent to transfer primary teachers from one place to another, but merely because such transfers were made on request of teachers, committee is not divested of its jurisdiction. This fact, it appears initially contrary to my case, Lordship. However, there's a law which is very well settled, Lordship. These directions are reasonable, and the District Education Establishment Committee followed the same principles in transferring the appellants on their request to avoid hardship which are posed to them. Hardship is also important here, Lordship. The respondents challenged the validity of the transfers before the High Court on another ground, also that the primary school teachers posted in the urban areas were not liable to be transferred to rural areas, though the state government had issued circular permitting transfers from urban areas to rural areas. The High Court did not interfere with the order of the transfer on this ground. Instead, it held that the transfer orders were without jurisdiction, as the same had been made on the appellant's request with a view to accommodate them. We fail to appreciate the reasoning ordered by the High Court. If the competent authority, this is important, Lordship, issue transfer orders with a view to accommodate a public servant to avoid hardship, the same cannot be and should not be interfered by the court merely because the transfer orders were passed on the request of the employees concerned. If hardship is expressed before the competent authority, Lordship, it can be accepted, Lordship. They can sit over my matter, Lordship, and come to a logical conclusion, Lordship. The respondents have continued to be posted at their respective places for several years. They have no vested interest to remain posted at one place. Since they hold transferable posts, they are liable to be transferred from one place to another. I agree, Lordship. The transfer orders had been issued by the competent authority which did not violate any mandatory rule, Lordship. Therefore, the High Court had no jurisdiction to interfere with the transfer orders. 4. In our opinion, the court should not interfere with a transfer order which is made in public interest. May I pause for a moment, Lordship? Both the orders 10-10-2022 as well as 9-11-2022, both the orders were issued in public interest. It has been clearly stated, Lordship. And for administrative reasons, unless the transfer orders are made in violation of any mandatory statutory rule or on the ground of malafide, a government servant holding a transferable post has no vested right to remain posted in one place or the other, is liable to be transferred from one place to the other. Transfer orders issued by competent authority do not violate any of its legal rights. May I stop there, Lordship? My respectful submission, relying on this principle of law, Lordship. The orders were passed in public interest and for administrative reasons, Lordship. Though apparent from the report that no reasons were stated, Lordship, but they have considered my representation. And this is very clear, and they have filed the affidavit stating the same, Lordship. But the question of incident of service, Lordship. Incident of service. Okay. 1993, Volume 4, SSC 357, Lordship. 1993, Volume 4, SSC 357, Lordship. Paragraph 6 and 7. 6 and 7. If your Lordship got it.
Yes.
Paragraph 6 and 7.
Yes.
an order of transfer is an incident of government service. Fundamental Rule 11 says that the whole time of a government servant is at the disposal of the government, which pays him, and he may be employed in any manner required by proper authority. Fundamental Rule 15 also says that President may transfer a government servant from one post to another. That the respondent is liable to transfer anywhere in India is not in dispute. That the respondent is liable to transfer anywhere in India is not dispute. It is not the case of the respondent that the order of his transfer is vitiated by Malafites on the part of the authority making the order. Though the tribunal does not say so merely because certain guidelines issued by the central government are not followed, with which finding we shall deal later. The respondent attributed mischief to his immediate superior who had nothing to do with his transfer. All he says is he should not be transferred because his wife is working at Shillong. His children are studying here, there, and also because his health had suffered a setback. From time ago, he relies upon certain executive instructions issued by the government in that behalf. Those instructions are in the nature of guidelines. They do not have statutory force. 7. Who should be transferred? Who should be transferred? Where is a matter of the appropriate authority to decide? Unless the order of transfer is vitiated by Malafites or made in violation of statutory provisions, the court cannot interfere with it. While ordering transfer, there is no doubt the authority must keep in mind the guidelines issued by the government on the subject. Similarly, if a person makes any representation with respect to his transfer, the appropriate authority must consider the same having regard to the exigency of administration. Very clear, Lordship. The guidelines say that as far as possible, husband and wife must be posted in the same place. The said guideline, however, does not confer any upon the government employee a legally enforceable right, Lordship. Now the question of medical grounds, Lordship. Why I say that it is an extraordinary case, Lordship. 2021 SSC online, Gauhati 1309. 2021 SSC online, Gauhati 1309, Lordship. May I read the Lordship? Yes, paragraph 8, 9, and 11, Lordship. Yes. This is a similar case, Lordship. Paragraph 8, in the case in hand, Lordship. Paragraph 8. Yes. The petitioner has annexed a number of office memorandum and also record office instruction, as have been indicated above. From the record office instruction, it transpires that if the husband and wife are working in the same department, posting of both spouses together the same station where required level of facilities as are available is to be considered on to enable them to lead a normal family life and to look after the welfare of their children, especially till they attain 18 years of age. Office memorandum dated 6/6/14 has formulated a government employee who has a disabled child serve as the main caregiver of such child, and thus any displacement of such government employee will have a bearing on the systematic rehabilitation of the disabled child, since the new environment setup could prove to be a hindrance for the rehabilitation process of the child. There's also one reason, and my reason why I stated in the representation is that there is no proper facility at Mon, Lordship. That is my reasons, Lordship. In such situation, a government servant who is also a caregiver of a disabled child may be exempted from the routine exercise of transfer. It is very clear, Lordship. Rotational transfer subject to the administrative constraints. This has the reference from the government's affidavit, Lordship, the office memorandum produced by the government, Lordship. The subsequent guidelines have also highlighted the same position. Office memorandum 8/10/2018, this is the OM referred by the government, Lordship, is on the subject exemption from the routine exercise of transfer, rotational transfer. It mentions that the government caregiver of dependent daughter, son, parents, spouse, brother, sister with specified disability as certified by the certifying authority as a person with benchmark disability as defined under Section 2R of the Rights of Persons with Disabilities Act may be exempted from the routine exercise of transfer, rotational transfer, subject to the administrative constraints, Lordship. Para 9, Lordship. Now, this does Facts are identical in nature, Lordship, in this case, Lordship. It appears from the documents annexed to this writ petition that the child of the petitioner born on so and so is suffering from Down syndrome, the same medical condition with my child, Lordship, associated with deficit hearing impairment. Doctor has already stated that I have 50%, Lordship. The respondent's child has 50% disability with mental retardation and deficit in intellectual functioning. The petitioner and his wife are treating their child in different medical institutions, including so-and-so, Gauhati. In the letter dated so-and-so, the commentant so-and-so, while forwarding the representation of petitioner, had also opined that the child of the petitioner required constant medication and supervision of the parents. He had also recommended for extension of the tenure of the petitioner for a period of 1 year to look after their mentally retarded son. Lordship, for the similar aspect, Lordship, the government has taken a decision to accommodate me at Dimapur, Lordship, by that temporary arrangement which I have produced before the Honorable Court, Lordship. 11, Lordship. In view of the observations made above, the court deems it appropriate to dispose of this writ petition with a direction, Lordship, to the competent authority to take representation filed by the petitioner on board for reconsideration. While considering the representation, the competent authority shall also take into account the official guidelines regarding exemption from routine exercise of transfer, as have been formulated by the office memorandum so-and-so, and shall thereafter dispose of the same by passing a speaking order as expeditiously as possible, preferably within a period of 1 month. The order so passed shall be communicated to the petitioner forthwith. So-and-so, so-and-so, Lordship. This is a similar case, Lordship.
Yes.
Lordship. I'll be relying on paragraph 5, Lordship. Paragraph 5. 5, 18, 19, and 20, Lordship. 5, 18, 19, and 20.
Yes.
5, it has reproduced about the office memorandum 2018. So to save this precious time of this Honorable Court, I need to read it, Lordship. If I, Lordship may allow, I'll rely on paragraph 18, 19, and 20, Lordship. 18, 19, and 20. If the Lordship got it?
Yes.
There's a short paragraph, Lordship. 18.
Yes.
Various other provisions have been incorporated in the Act to ensure that the persons with disabilities do not suffer from disadvantage. It is in that context the role of parents become critical and crucial and important, and in any way cannot be undermined. It is in that context the service conditions of the employees, more particularly those who are having physically challenged dependents relating to transfer, are sought to be governed by issuing the aforesaid office memorandum, Lordship. 19. In view of the above, this court is of the opinion that even if the state of Assam has not framed any such memorandum, rules or regulation, similar with the state of Nagaland, Lordship, there's no such rules. It would be under legal obligation to follow the principles mentioned in the aforesaid memorandum, that is 2018 memorandum, Lordship, in respect of their employees having similar problems. 20. Accordingly, this court would hold that till such adoption or framing of any appropriate rules or memoranda in this regard, the aforesaid office memorandum issued by the central government ought to have been followed by the state government, since the aforesaid memorandum had been issued for effective implementation of the provisions of a parliamentary enactment which is equally applicable to the state of Assam. So it is with regard to the application of that office memorandum, Lordship. And office memorandum clearly states to appreciate and also to consider if an employee expresses about those difficulties, the hardship which I have also relied upon in the authorities, Lordship. The last authority, Lordship. (2005) 8 SSC 760, Lordship. (2005) 8 SSC 760, Lordship. Paragraph 21.
Paragraph 21.
21, Lordship. Paragraph 21. May I read it, Lordship?
Yes, please.
For now, Lordship.
Yes, yes.
Doubtless, he also seeks to invalidate or nullify any act or order must establish the charge of fate, an abuse or a misuse of by the authority of its powers. While the indirect motive or purpose of that fate or personal ill will is not to be held established except on clear proof thereof, it is obviously difficult to establish the state of a man's mind. Lordship, I'm on the question of malified intention, Lordship. For that, it is what the employer has to establish in this case, though this may sometimes be done. The difficulty is not lessened when one has to establish that a person apparently acting on the legitimate exercise of power has, in fact, been acting malified in the sense of pursuing an illegitimate aim. It is not the law that malifies in the sense of improper motive should be established only by direct evidence, but it must be discernible from the order impugned or must be shown from the established surrounding factors which preceded the order. If bad fate would vitiate the order, the same can, in our opinion, be deduced as a reasonable and inescapable inference from proved facts. It cannot be overlooked that the burden of establishing malified is very heavy on the person who alleges it. The allegations of malified are often more easily made than proved. And the very seriousness of such allegations demands proof of a high order of credibility. Now, my respectful submission before this honorable court is that the petitioner has failed to make out a case because for question of transfer lordship, there is only 3 grounds for interference of this honorable court. None of the grounds has been made out, lordship. Therefore, my respectful submission is that there's no violation of any statutory provisions. There is no malified proved in the allegations or maybe the pleadings filed before this honorable court. Thirdly, lordship, the authority who has passed the orders, he is a competent authority, lordship. Therefore, on this ground, lordship, and the exceptional case is that my transfer has been retained only for the sole purpose of my medical condition of my child, lordship. Therefore, my respectful submission is that the petitioner has failed to make out a case and it is a fit case to be dismissed, lordship.
Okay.
Lordship, may kindly allow me 1 minute
Okay.
to reply, Lordship. My letter friend, particularly appearing for respondent number 4. This argument is based on 2 grounds. First, Lordship, his argument is that there is no malified, there is no violation of procedural rules. The order is not issued by a person who is not competent. That is his first argument. From the beginning, Lordship, I made my submission that my case is not come under that. Because the issue in this is modification of the general transfer order which was issued in public interest. Therefore, as per the law laid down by the Honorable Court, modification cancellation of the transfer order has to be based on reason, to be stated in the order. By bringing reason by way of an affidavit, similar case they brought many reasons, medical condition of the child, whatever, so many reasons in the affidavit. However, it is the well-settled principle of law that the validity of the order has to be judged by the reason mentioned in the order, not and cannot be supplemented by way of affidavits. So that is the principle of law. Therefore, violation of malified violation of state rules, that issue are not comes under this case. So, my reference submission on that issue is misconception of law, misconception of facts. Secondly, Lordship, my learned friend tried to take this honorable court on the issue of medical crowd. As I've submitted, Lordship, I have nothing much to see on that issue because our son may be physically disabled or suffering from some physical disorder, Lordship. I have nothing much to say on that issue, Lordship. However, Lordship, the judgment relied by my learned friend about the transfer and retention on medical ground, all these are different from the facts of the present case, Lordship. It is not the transfer order was interfered or allowed based on the medical ground. I can see it's an obiter dicta. With due respect to the judgment rendered by the apex court, Lordship, those judgments are not relevant in the present case because facts are different, Lordship. The only issue, Lordship, which both the counsel appearing for the respondents fail to support is that, Lordship, they have not even placed a judgment with regard to modification cancellation of the impugned order passed on 9/11/2022. Let them produce at least some judgment. This modification cancellation is valid. No, Lordship. I've cited three judgments to Lordship. Clearly lay down the principle how the modification, cancellation, even events of the transfer order has to be issued. Admittedly, no reason, nothing. Bringing the other grounds by way of an affidavit cannot be accepted as per the law laid down, Lordship. Therefore, Lordship, and Lordship, me kindly consider one aspect of the matter. Apart from the law laid down by the apex court, Lordship, your submission is based on the medical ground. Now, the transfer modification order was issued on 9/11/2022. This honorable court stayed in view order, and in view of the estate Lordship, transfer has been affected. Your submission is that there is no medical facilities to treat the child at most, but it's more than 1 year. The child is still alive, survive. Therefore, Lordship, submission based on medical ground of the child is baseless, Lordship. Okay. Therefore, Lordship, prima facie, the impugned order dated 9/11/2022 cannot stand the test of law because no reason, nothing has been mentioned for modification cancellation. I conclude my submission. Obligation.
So, Mr. Moajamin, this order 29 February 2024, where would we find that it's temporary arrangement?
What we consider demands.
Oh, is it against the, okay, okay.
Yes.
Vacancy due to study leave of, okay, okay.
Yes.
Okay.
Sorry. But whenever you are serious, that's one.
See, policy, transfer and posting policy, then one can be in one particular place for the entire service life and can also be transferred within a month.
And,
That's
and some other departments, there is a transfer policy which is provided under the service role also. One should at least serve for 5 years, 7 years like that. But in respect of higher education department, I've not come across any transfer policy.
Okay. Okay, Mr. What is Amir, Land Council for the petitioner. Staff. I've also had Mr. Mohammed, National Government Advocate on behalf of the state respondent, and Mr. Mohammed. Sorry, Moazamir. Land Council. For respondent number 4. Okay, hearing concluded. Judgment reserved, huh? Okay. I'll pass order.
Oblige.
Your last citation,
Lordship.
there also kindly give the copy.
Lordship.
No, Mr.
So,